All right, we're back on the record regarding the suffix 0385. That's Felicia Lipton versus Detroit Legal Group. Let me change your name.
I apologize. I'm using my daughter's laptop. That is her name is appearing.
Yeah, no, not a problem, ma'am. Just so we know where you are, we're going to change that.
Yes, sir.
All right. All right, so Ms. Lipton, let me have you raise your right hand to be sworn at this time, ma'am. As you prepare to present your case, you do solemnly swear affirm that the testimony you're about to give is the truth, so help you God, ma'am.
Yes, sir, Your Honor, I do.
All right, thank you, Ms. Lipton. Ms. Lipton, you went to Mr. Clay Miller at Detroit Legal Group for purposes of legal services. Is that correct, ma'am?
Yes, sir, Your Honor, that is correct.
When was that, ma'am?
I'm so sorry, I don't have the exact date, but I do believe it was last year, 2023, back in, one moment, I can go to the paperwork.
Right, so about April 3rd of 2023, is that correct, ma'am?
Yes, sir, around April 2023. Yes, sir, Your Honor.
All right. And you paid some money when you went there to for legal services. Is that correct, ma'am?
Yes, sir, Your Honor, that's correct.
How much money did you spend?
It was 2,500.
And you paid that after discussing the kind of case that you wanted the Detroit Legal Group to handle for you. Is that correct, ma'am?
Yes, sir, Your Honor. It was discussed by phone before I was even informed to come in by Mr. Clayton, Attorney Clayton Miller. We had a conversation by phone as to what the cost would be, and Attorney Clayton Miller mentioned that he needed all of the documentation to support my innocence in the matter. And so I made sure that I provided very detailed documentations to support.
We're not there yet.
Oh, I'm sorry. Sorry.
When you talked to Mr. Miller by phone, you told him what kind of case it was. Is that correct?
Yes, sir, Your Honor, I surely did.
Okay, what did you tell him about the case that you had that you needed some assistance in? Right.
Oh, okay, Your Honor. So I mentioned to Attorney Clayton Miller, well, the first thing that I asked I'm sorry.
No, I just want the initial thing. You called or you made some contact with the office. You says, hey, I need legal help, et cetera, et cetera. What did you tell them you need legal help for? I know later on there's a deeper discussion, but what was your initial contact? What did you tell them that you needed help for? Go ahead.
Yes, so I mentioned that this was a case that involved my daughter, who is severe mental ill. I explained that she was born very early due to me suffering from total placenta previa, and that I filed an incorrigibility upon my daughter because she was putting herself in harm's way as well as our family. And I had been informed to pick up my daughter, and she's not in her right sane mind. They had taken her off of all of her medications at Wolverine juvenile facility. I mentioned that my daughter has been attempting to commit suicide. She was being abused. She was being neglected. They stripped her off all of her clothes. They put her into a room, left her there. I just explained everything, and I stated that I'm not a negligent parent. I'm an excellent parent. I have 5 children. I explained to him what I did for a living, that I would never risk my licenses, my certifications, and I needed assistance to show the courts that my daughter is being abused and she's not well and is unsafe to the community, myself and my family, to bring her home, and that I had evidence to support everything, and that CPS higher-ups did not find me negligent, and that the case was dismissed, and that I'm not an adjudicated parent. I'm just a parent trying to keep my daughter safe as well as my family, and that she needed to come out of Wolverine, who is abusive. They're not treating her, and that is my belief that other children are being abused as well, and that they were in the process of closing that facility. And actually, Your Honor, they did.
All right, so that was the initial conversation that you had telephonically. You kind of went over the cornucopia of things. Then you came into the office after someone advised you of the $2,500 fee, and you came to the office to pay the fee. Is that correct?
Yes, sir, Your Honor, and that was Attorney Clayton Miller. He stated he wanted me to come into the office. He wanted me to bring in $2,500 to be presented. I asked him over the phone, do they handle juvenile cases? Because even though it was my case, still it was in representation of my daughter, pretty much, but he was actually representing me. So I asked him, do he handle these sort of cases? And he stated, well, it's actually a juvenile case and we do handle these sort of cases. He kind of hesitated, but then that was the response. So I kind of felt comfortable, and I told him I didn't really want to come in to the office to pay the $2,500. I wanted to bring the $2,500 to the courts, because I know how this works. You sit in the office, there's a conversation for 2, 3, 4, 5 hours. It may not be productive, it may be productive, and I didn't want to have to be charged for a lot of hours. I just felt kind of uneasy, because everything was like, just, I don't know, he kind of kept everything kind of short. While I'm trying to be detailed, he kind of kept it short, and that kind of puzzled me. I was puzzled kind of the whole entire time, but he says, no, you have to come into the office or we would not be able to show up in court. So that's what made me come in and say, okay, I'll bring the 2,500. And I brought my daughter with me and
Right.
actually recorded the entire conversation.
Did this happen the same day when you initially called the office?
No,
Yes
sir.
or no?
No,
All
sir.
right, was it a day or a few days later when, how much time expired?
So I believe I talked with Attorney Miller that Thursday, I believe it was, and the court hearing was, I believe, that next Monday, that following Monday. So I do recall him saying, hurry up and get the information to me by email so I can review everything over the weekend in order to represent you on Monday. So he had Thursday, Friday, Saturday, Sunday. Monday was like the court hearing, if I'm recalling correctly. And that's my evidence and supports.
You do realize that you didn't answer my question. Mine real simple.
I'm sorry, Your Honor.
You went to the office to pay some money. When did you go to the office? Was that the same day or the next day, or you went to the office on Monday? When did you go to the office?
I'm sorry, Your Honor. So it was the same day after we talked. I went that Monday, the same day of the court hearing.
Okay. So you took the money on the same day of the court hearing?
Yes, sir, but we had a conversation that Thursday before.
On the phone?
On the phone. So the conversation was on a Thursday. I believe it was a Thursday. All the evidence was supported to him that Thursday. He wanted me to come in Monday.
That's when you went to the office and brought money, correct?
Yes, sir, Your Honor.
And then the court date was Monday too, as well, true?
Yes, sir, Your Honor.
Okay, all right. So tell me, tell me what happened as far as the breakdown. You go to court on Monday, and tell me what happened. Give me some information about that.
Okay, but Your Honor, I just want to make sure the honorable courts understand, we had a conversation that Thursday before that Monday, and all the evidence was provided to Mr. Miller, Attorney Miller, I'm sorry, that Thursday before the hearing.
6 times.
Okay,
Every time I asked you a question about something else, you told me about that again.
all right.
You told me that your initial conversation, then you were to get papers there, and then you talked about it extensively, and you had several conversations. You told me that over and over again. At some point, you went to court, and tell me what happened. Now that you hired a lawyer, you paid the money. Tell me what happened.
Okay, thank you, Your Honor. Okay, so we went to court that Monday, and what happened? Attorney Miller made a, I think he had a conversation, if I'm not mistaken, with, I want to say with the people. I believe it was either I want to say probably the prosecuting attorney or something like that. And after this conversation, if I'm recalling correctly, he came out to me and my daughter, and he totally flipped the script on me. He started saying to me, "Oh, you're playing with the state. You can't be playing with the state like this." He was like, "You was asked to pick up your daughter, and you didn't pick up your daughter." And he stated to me, I don't know what to do. I just don't know what to do." He was like, and I recorded it, my daughter recorded the entire conversation. So I said to him, I was like, "I explained to you, Attorney Miller, every single thing, and I was honest with you about every single thing." I stated to him, I was almost like in tears because he was like this different person. And my evidence supports the fact that he knew that I did not pick up my daughter because my daughter was not in her right sane mind. Picking up my daughter from that facility would have not only put her in jeopardy. This is what I said to him. It would not only have put her in, and I stated to him, I'm saying this again, it would not have put her in jeopardy, but it would have put my family and the community in jeopardy. Okay, the psychiatrists have taken her off all of her medications. She's not in her right state of mind. It's unsafe. He says to me, "Well, I need to make a phone call." He made a phone call to a gentleman by the name of Ryan, which that name was very familiar because before I was assigned to Attorney Miller, I had a conversation with, I believe, very brief with Attorney Ryan. And he started saying he didn't know what to do. He didn't know what to say. It was like he didn't know what was going on with the case. And I said to him, "You have all the information to support the fact that I'm not an adjudicated parent. I am a parent that is trying to keep my daughter safe, and she needs to come out of that facility where she's being abused, and you could assist with that as well." And I stated to him, I says, it's a lot of things going on. She's been abused in this facility. I need her out of that facility. I'm not an adjudicated parent. I am the one that filed a incorrigibility so that my daughter can stop putting herself in harm's way as well as our family. And I stated to him, I was like, "Why are you turning on me now?" And it was horrible. And imagine being a parent. And I said, I'm a parent that is grieving for my daughter, and I'm grieving for myself. I told him, I was like, CPS has dismissed the case against me. It took the higher ups to do it because the local CPS office would not. I explained this to him again. They would not. It's like they didn't even want to hear me. It took the higher ups to say she's not guilty of this. She done sent 1,001 pieces of documentation to show she's innocent. And I told him, "Why won't you represent me and bring all of this evidence to the courts?" He still pretended like he didn't know what to do. And so from that point, he asked for an adjournment. He told the honorable judge, he says, "Well, I'm just getting the case." It was almost as if like he didn't have nothing. I'm just getting the case and I'm requesting an adjournment. And I believe it was because he didn't know what to do. I really believe that because he had everything to support my innocence as an excellent mom that's loving, nurturing. And he got the adjournment and he came out and I said to him in tears, I said, I'm sorry. I I can't move forward with you as an attorney. This is my life. Like I said to him, I was like, I'm not a negligent parent. I'm not even an adjudicated parent. I came to the court for help with my child so that she can get the treatment that she needs. She's not in her right mind and they are abusing my daughter. And so he, from that point, I can't remember, I think, if I'm not mistaken, he stated that he wanted some time or something of that nature, you know. But yeah, that was the conversation. And I did submit, Your Honor, all the evidence to support the conversation. Everything is on flash drive, everything that happened in court is on flash drive. The honorable courts have everything. You guys also, the honorable courts also have all the emails that he was fully prepared. I made sure that his firm had everything. He had everything to support my innocence, to support that I'm nowhere near a negligent parent. Not only am I a loving and caring and very thorough mom, but I told him, I was like, I have a lot to lose. You know, my education, my nursing and education job. I was like, please, like what is going on? So that was the conversation.
All right, man. All right, before the attorneys may very well have questions to ask you, let me ask you very quickly that that's the only time that the law office, that is Mr. Miller or Detroit Legal, came to court. Is that correct, ma'am?
I'm so sorry. I'm so sorry.
Only time they came to court with you, correct?
Yes, sir. That was the only.
Yes or no question. Thank you. All right. And at that hearing, was there any determination made by the judge or referee or whoever it was? Was there any determination made that you were an incompetent parent or anything? Did they make any determination like?
No,
Right.
you're.
Listen to me careful. Listen to me careful. Was there any? Did the court make any decision regarding your parenting or anything about you as a person? Did the court make any decisions about that?
No, Your Honor, I had to hire another attorney. That's where that came in, where.
Ma'am, you answered my question there. Now, let's go on before I come to the attorney on the other side who wants to ask you questions, because I believe at the previous time you mentioned that you terminated the services of Mr. Miller in the law firm and you went to someone else, correct?
Yes, sir, Your Honor, I did.
How soon after that particular hearing there in April of 2023, how soon after the hearing did you hire someone else to take on the case for you? How
Yes.
long after that?
I believe, Your Honor, I had to get on it right away. I hired an attorney. I believe it had to been maybe about a couple days after, maybe about a couple days to a week after. I actually submitted that to the honorable courts as well.
Let me say it like this. I don't really care about the submission of those things. I want you to tell me, okay? All right?
Yes.
And a short time after that, you hired another lawyer, and that lawyer went with you to the next hearing, correct?
Yes, sir, Your Honor.
How long was the next hearing? I know it was adjourned from this year. How long was it? A week later, 2 weeks later? What was it?
Well, actually, Your Honor, Attorney Miller wanted me to give him the opportunity. So I wanted to give him the opportunity to go to the next hearing, which he didn't show up for. He pretty much stated, just give him the opportunity to represent me. He knows that I'm innocent. He could tell I'm a good parent. So that is how that came about. So I end up telling the principal that I would go to the vehicle if that's okay with them, so that we could have this hearing in behalf of my daughter. I gave them documentation to support that I would be in, what was going on. He didn't show up. He did not show up.
By that time, you had another lawyer, right?
No. That attorney, so the hearing was like, I want to say maybe a week or two away. So I hired another attorney. I want to say that following week, but it was adjourned. The adjournment was way later. I think maybe about probably a month later or 3 weeks later or something like that.
Right.
And then so I went to my vehicle, there was, I can't remember what that hearing was. It wasn't nothing to where, I can't exactly, it was something short and quick or something. I can't exactly remember what it was, but he didn't show. And I did let the honorable courts know that I had hired that I would be hiring, I think it was, another attorney. And that was, I think, the following maybe week or two later or something like that. And then he contacted the courts for his appearance for the next hearing to let them know that I had hired him.
All right, thank you, ma'am. Anything else you want to tell me?
I do want to say, Your Honor, after hiring the other attorney, he did contact the courts. He made his appearance. The case was a win for me. He was prepared. He did stand up and let the honorable judge know that he was prepared to show evidence that I was innocent.
Judge, I'm gonna object to this narration, just because obviously there's no transcripts that have been provided. It's hearsay and it's completely irrelevant.
I'll have to sustain the objection on the articulation of what another attorney may have said on the record in the court, because I don't have a record of that court. But that does not mean that those things didn't occur. I just can't hear you on those. Let me ask you this basic question. Now, were you satisfied with the outcome that you achieved in court?
Yes, sir, Your Honor. And actually what I did was I kind of figured that the defendant would state that today. So what I provided the honorable courts today was documentation to support that not only I hired the attorney, and I actually started to receive the transfer. That was actually my first mine, but in between working 3 jobs in school, I didn't have the chance to do that, but I did provide to the defendant as well as to the honorable courts documentation that shows the attorney that I hired, and that attorney could actually be subpoenaed to court if this was to go into another hearing to testify that Ms. Lipscomb was not found guilty of negligence of not picking up her daughter. And that.
And those are a bunch of the things that I told you are not relevant. That doesn't mean anything, okay? This case is about you paying an attorney fee, you fired a lawyer, you hired another lawyer, you got satisfaction, you want your money back. That's what this case is about. All right.
Yes,
anything else that might be relevant? Then I'm going to let the attorney ask questions. Anything else you want to tell me?
Yes, sir, Your Honor. And I would like to state that the conversation that I and Attorney Clayton Miller had over the phone, the conversation was not even, if I'm recalling correctly, it wasn't even, I think, a half hour, maybe 20 minutes or so. And I did list that in my evidence as well. And I also have phone records that support. The conversation was very short and brief. I was very thorough when I initially spoke with him that Thursday before that Monday of the hearing. When we came into the office, I have evidence to support even my recorded conversation while we were in the office supports the fact that we were there for approximately, if I'm recalling correctly, I think like 2 hours or so. And Mr. Attorney Clayton Miller pretty much abused that time frame while we were there. He was not focused really specifically on me. He was pretty much more focused as the conversation that he and I had he was pretty much more geared toward my daughter. His conversation to me was not geared toward how I'm going to assist you. This is what I'm going to do. He had all the evidence to support, and he was browsing through his email. He can't find this. He can't find that. He can't find this. I said, well, and the flashlight support. I says, well, I sent you everything. You have everything. He basically pretty much overlooked all the evidence that he needed to support me thoroughly in court to get me the positive resolution that the attorney went straight in, the other attorney that I hired went straight in and did. So you could sit with an attorney for 15
Judge, I'm
hours.
gonna object this line of questioning. We're talking about sitting down with other attorneys now. This has all been stated several times.
Well,
suspend it.
actually,
Excuse me, I'll suspend the objection, in that regard. There are some things that, you've been able to tell me that are relevant to the case, some things are not relevant. It's obvious that you hired someone else and that you, got, the relief that you wanted. All I'm really concerned about is what happened here, and I believe that you've told me. So let me go to Mr. Hill. He may have questions for you by way of cross-examination. You may have time to.
Thank you, Judge. Judge, I guess as a preamble, Ms. Lipscomb's making reference to a lot of documents submitted to the court. The only documents we have are the ones that she originally submitted. Maybe I'm mistaken, and Mr. Potts and Mr. Miller can chime in as it relates to phone records and additional things. Guys, have we received anything as it relates to the documents she's making reference to?
I'm sorry, the records that I'm making mention to, and
Ma'am, there's no question.
No, of course, you know you can't. You know.
Sorry, Judge. Mr. Miller, did the phone record she's indicating she's made reference to, do we have anything from Ms. Lipscomb prior to today's trial?
We've got a lot. I didn't see any phone records.
No.
There's
What I'm
a lot of
asking, Mr.
recordings.
Clay, I'm asking, since she filed the lawsuit, has she provided the exhibits that she submitted to the court? That's what I want to know.
Yeah.
Okay. I'm ready to go.
All right, now, ma'am, put the paper down. Thank you.
Ms. Lipscomb,
Listen to the question very carefully. I'm going to unmute you. Listen to Mr. Hill's questions very carefully and respond to his questions. I can't let you just talk and talk and talk. Respond to his questions as best as you can, man. Go ahead, Mr. Hill.
she's on mute, Judge.
I've already given her permission. Go ahead and unmute that.
Ms. Lipscomb, I'm going to ask you a series of questions. For the most part, I'm going to ask for yes or no answers. If you feel the need to explain, ask me, and I'll let you know if I'm going to require that. The judge can also ask some questions based on what I'm asking. Now, you originally said you contacted the office, I believe, which would have been March 30th, which is a Thursday. Is it possible that it was that Friday, the 31st, before the Monday? Is that a possibility?
I'm pretty sure it's in my detailed records that's in front of me right now, but off the top of my head, possibly between Thursday and Friday.
Okay. If you need to refresh your recollection by looking at those records, you can. And wouldn't it be more accurate that you actually called the office in the latter part of Friday, March 31st? Would that be a better?
It seems more to me like it would have been March 30th. I believe either March 30th or the 3rd. It was one or the other. If you would allow me to look at my record, I can give you a for sure date.
It's okay. We can get to that later. So it was either the Thursday or the Friday, and you'd agree with me that it was in the latter part of the afternoon. Yes or no?
I can't exactly remember the time frame, but I'm pretty sure it was. I can't exactly remember the time frame, but I want to say probably between 10 and 12, probably that Thursday.
Okay, so you don't recall being on the phone with Mr. Miller past 5 o'clock on the 30th or the 31st, correct?
Are you saying the initial call being at
Yes.
5 o'clock?
Yes.
I would have to look at my email. And because if I'm not mistaken, I believe I made comment in my email to him as to the date that I initially contacted him. Because usually when I do an email to someone, I always reiterate when I spoke with
Lipscomb,
you.
there's no question pending right now, ma'am. Thank you. Okay, Judge, can you give me the ability to share screen?
Sure.
Ms. Lipscomb, while the judge is doing that, shortly after the conversation you had with Mr. Miller, I would say that very day or that within a few hours, you started submitting documents to Mr. Miller, correct?
I started submitting a
Yes or
lot
no?
of documents immediately, yes.
Okay, all right. So I'm going to show you.
those are my documents to you all.
I understand that. And you'd agree with me that it looks like, although there's no times on them, you'd agree with me that, and I'll have Mr. Miller testify to the times, that you'd agree with me that all these dates are March 31st, correct? I'm going to show you another one. This is just one set of emails. I'm going to show you another set of emails here in a second. Can you see that, Ms. Lipscomb?
I can see your screen.
Okay, and you agree with me that this is a continuation of the first ones, which would appear that Friday, March 31st, 2023, that's when you started sending the emails. Is that correct?
Actually, I'm pretty sure that there's other emails that I sent as well. So you're showing me your information, but if I go back to my records will show if there are emails previous to that date.
Miss
Because
Lipscomb?
Let me interject here, ma'am. I guess at the heart of the question is it in fact true that at least those emails are a number of emails that you sent, and you're saying there may be more? Is that correct?
Yes, I believe there's more emails on it could be more emails because it does say email 2 of 2. So one of 2 could have been from the day before, but I would have to look at my.
Ms. Lipscomb, the emails that I show you, I'm not trying to trick you. I asked Mr. Miller to send me a screenshot of all the emails you sent. All of them start on March 31st, Friday. Okay, that's all we have. If you have something different, you can look for it when I'm done, and I'm actually asking Mr. Miller questions. You can look for it to contradict that. But if all the emails that we have are from March 31st, Friday, that evening, all right, is there any reason why you don't agree with that the emails started coming on that Friday?
I need to recollect and
Okay.
look at my records to see if they came in.
No problem.
On the 30th. It could have been the 30th.
No problem. You just said that you started sending documentation immediately, correct?
I did immediately after speaking with, but again, immediate could be on the 30th or the 31st. I can't tell you that I started on the 31st
Ms. Lipscomb,
if
Ms.
it could
Lipscomb.
have been the day before.
Let me stop. Ma'am, listen, just answer the question, ma'am. You know, if we're gonna, and I'm not gonna let it happen, if I'm not gonna have a trial about Webster's dictionary about immediately, and whether or not immediately means an hour or within 24 hours or within 48 hours. I would have to find, if I was finding something, that after the parties initiated a relationship through discussions, that at the earliest opportunity, Ms. Lipscomb started sending emails of documents. That's been her testimony. That seems to be the testimony here. The only dispute seems to be whether this started on the 30th or the 31st. And listen, to a certain extent, that's relevant, and to another extent, it's not even really relevant. We know that on one of those days is when all of this started, and we know that that there came a time when some money was exchanged after several emails had already been sent, and then other documents were submitted. I mean, I think that's axiomatic here, because Ms. Lipscomb's testimony says that, and also Mr. Hill has presented some pictures and documents showing that it's true that several items were submitted. Now, whether the parties first talked on the 30th of March or first talked on the 31st of March, I don't have to get into all those weeds. The truth of the matter here is that there were conversations had and multiple documents were sent to the law office. All right. So with that in mind, let's move forward, Council.
Judge, I just want to say one thing. I think it is important whether that's the Thursday or Friday, and I'll just make this point and I'm going to move on, because our documents support that it was Friday. Mr. Miller's in the office till after hours. Her hearing's on Monday. I think that's very important as it relates to a lot of things in terms of why there wasn't a fee agreement signed. So I'm going to move on, Judge, but I want the court that's my position, is that you get a phone call at 3 or 4 o'clock on a Friday for a hearing at 1:30 on Monday, and you have somebody begging for your assistance. If we would have had that extra day, that's a huge amount of time that I can sit down with Mr. Miller and we can go over everything, and we're not going to request an adjournment. That's all I want to say, Judge.
And I would like to speak toward what you stated. Attorney Miller stated he would review all of mine.
No. here's the thing, Mr. Hill. To the extent that Mr. Miller testifies to what his experience was in relationship to receiving documents and what he did and what his actions were, that's the testimony of the attorney that handled this matter. Ms. Lipscomb is not an attorney. She knows what she did to the best of her ability, that she started sending a bunch of documents, and at some point she paid some money. Mr. Miller, I take it, is going to testify that he went through those documents, and if he received them on Friday, and he took out some time on Friday to try to prepare for Monday, whatever, I think that's going to come out in this case.
Sure. I'll move on, Judge. Ms. Lipscomb?
And Ms. Lipscomb, don't talk until you get a question.
No, she's muted, Judge.
I'm working on unmuting her. Don't talk till you get a question. Now unmute yourself. And then Mr. Hill has some questions for you. Go ahead and unmute yourself.
Yes, sir,
Go
Your
ahead.
Honor.
Ms.
Go ahead,
Lipscomb,
Counselor.
how long did the first conversation when you first called the office, how long did that last with Mr. Miller?
I want to say we only had, I want to say approximately maybe 15, 20 minutes or so.
Okay. Did you ever have another conversation with him over the weekend prior to the hearing? Yes or no?
No, I don't think we had any other conversation because
Thank you.
Saturday,
Thank you. And isn't it true you also sent several text messages to my client between the initial call to the office and the day of the hearing? Yes or no?
I can't recall that. I would have to go back to my documentations to see. I can't recall that.
You recall sending any text messages at all?
I don't recall. I don't recall any text messaging. If I would actually, I can go to my phone and I can give you a direct answer if I can go right to my phone right now.
Don't need that. Thank you, Ms. Lipscomb. So you're saying that you're not sure if if you communicated via text message with Mr. Miller between that Thursday or Friday to the time of the hearing, correct?
He stated to me that Thursday, I believe it was that Thursday to come, he wanted me to come in that Monday.
Ma'am, you're not listening to my question. Was there any other communication with our office whatsoever between the initial consultation when we told you the price and when you came in to pay on the Monday? Was there any communication back and forth whatsoever besides the emails?
I think if I'm recalling correctly, I believe, Attorney Miller saying that I didn't feel comfortable, I believe, or something like that. Coming into the office to pay, I wanted to pay the fee in person on the
Sure.
court.
So if Mr. Miller was to provide documentation, text messages that you were communicating all throughout the weekend, that wouldn't be accurate, would it?
I just stated to you, sir, that if I sent any other text messages, I would have to look at my phone to support what those text messages were. And matter of fact, I believe I provided that documentation as well. I provided everything. Oh, I
Thank you, ma'am.
provided messages
Thank
and
you, ma'am.
everything to you all and to the honorable courts.
Excuse me. I told you before, ma'am, I'm not concerned about what you provided and all of that. If you have a question, the question is this: whether or not, prior to your coming into the office, whether or not you sent and or received any text messages between yourself and the Detroit Law Center or Mr. Clay Miller, from the first time that you spoke with someone at the office till you came into the office. Were there any text messages sent? That's the question, ma'am. If you know, say yes. If you don't know, say I don't know.
I believe there were a few, and I believe I provided that to the legal group as well as to the honorable courts.
Thank you,
Yes,
Mr.
you
Lipscomb.
provided that. All I care about is the answer. You believe that there were some, okay? Thank you. Mr. Theo, go ahead, sir.
Ms. Lipscomb, you agreed to pay the $2,500, strike that. On the Thursday or Friday, Mr. Miller indicated to you what it would cost, a $2,500 flat fee retainer to address your matter. Yes or no?
I'm sorry, repeat the question.
Mr. Miller on Thursday or Friday told you the price would be $2,500, a non-refundable retainer, a flat rate retainer to represent you for the show cause. Yes or no?
I did agree to pay it with
Yes
the
or no, ma'am?
with
No,
the
ma'am,
understanding that
ma'am.
he was trained Oh, yes.
Yeah.
Yes,
Okay. And you indicated after having a conversation with him on Thursday or Friday that you agreed to the price of $2,500, correct?
yes, I did.
Okay. And did you pay it on that Thursday or Friday? Yes or no?
He told me to bring it in that
Ma'am,
following
ma'am,
Monday.
ma'am, did you pay it Thursday or Friday? Yes or no?
He didn't ask for me to pay it Thursday or Friday.
So the answer is no.
No,
Okay. Did he send you an invoice between Thursday and Friday to your email address? Yes or no?
I can't exactly recall the date or
Okay.
the time frame, but it's in
Your
my
prior-
email.
Sure. Your prior testimony was that Mr. Miller indicated he would go over the voluminous emails that you sent over the weekend, correct?
I'm sorry, repeat the question?
You stated to the court, you said that after you spoke to Mr. Miller on that Thursday or Friday, that he indicated he was going to review your case over the weekend, go over the emails, correct?
He told me to start sending in the documentation after we had gotten off the phone, if I'm recalling correctly, so that he could review my case and all my evidence over the weekend.
And at that point,
Hated it.
Judge, that's fine.
It's the same question he asked you. You don't have to give a commentary on it. He asked you whether or not you started sending in documents for Mr. Miller to review. That's a yes or no question. It sounds like, your answer is yes. And you want to say something else, but it's just yes. All right, next question, sir.
And Mr. Miller agreed to review your documents over the weekend on the Friday, when you said you were going to send them, and you still had not made payment. Yes or no?
He told me not to bring payment in.
Yes or
until-
no?
Yes,
Okay.
and he
And
never reviewed the document.
There's no question, ma'am. Okay. And isn't it true that you were being charged with a show cause to be held in contempt because of failing to pick up your daughter from a certain facility, correct? That's what Judge Miller was alleging, correct?
I'm sorry, repeat the question?
Well, he's asking you about the nature of the case. And so he's asking you a question about the nature of the case. He said, is it in fact the reason you hired the Detroit Law Center was because there was a show cause hearing that centered around Judge Miller and the court saying that you were in contempt because you didn't pick up your daughter? Is that what the case was about?
Yes, it was, and I meant,
Thank
yes.
you. Thank you.
Go ahead, Mr. Ryan.
The documents you submitted to Mr. Miller over the weekend, those were in relation to your defense to the show cause, correct?
That is correct.
Thank you. And Mr. Miller did tell you that prior to us actually attending the hearing, although he was going to review the documents, money had to be paid prior to the hearing. Yes or no?
Okay, repeat it once more.
Before we showed up to the hearing, that the retainer, non-refundable retainer, had to be paid before we went to the hearing. He told you that, correct?
No, he did not. I'm
Okay.
sorry, he told me it had to be paid before the hearing, but he never stated.
Thank
it
you.
was-
That's the only question I have, ma'am. That's the only question I have. Thank you. And you indicated to me, or you indicated to the judge that Mr. Miller, did he call you on the Sunday to tell you to come in on Monday morning, or did he tell you Monday to come in?
I can't recollect that.
Okay.
I
You
cannot
came into,
recall that
you came into the office.
in my records.
You came into the office on Monday around 10 or 11 o'clock. Is that accurate?
That's
Prior to the-
approximately correct.
Okay. And at 10 or 11 o'clock, this is about 2.5 hours before the hearing. Up until that point, you had not paid the retainer, correct?
Up to, are you saying was the retainer paid? Is your question basically asking me if the retainer fee was paid before Monday? Is that what you're asking?
Before you walked into our doors, had you paid the retainer? Yes or no?
No, because I was told to bring
Thank
it
you. Thank you. And you brought it that morning, correct?
like I was asked, correct?
Okay. And you had a conversation with Mr. Miller, who indicated that he was going to attend the hearing, correct? He said he was going to attend the hearing, right?
Correct.
All right. He asked you that after the completion of the hearing that we were going to submit a fee agreement to you to sign. You recall that, correct?
No, he did not. I
Okay.
actually
Ma'am,
asked
ma'am,
him.
yes or no? Thank you. All right. And you'd agree with me that we had about an hour, Mr. Miller had about an hour and a half prior to the hearing after you came in and paid, correct?
I would have to look at my time,
Sure.
my log
No
to
need to.
confirm that.
Don't need to. We're fine with that. So, now, there was a conversation, okay? And I was present in this conversation with Mr. Miller, and I want you to really think about this, okay? The goal, after being retained on that Monday morning, hours before the hearing, was to attend the hearing in person and to request an adjournment. And is yes or no? Was that the goal? Yes or no?
No, I don't recollect that, because how would he know that?
Ma'am, that's fine. Ma'am. So what
I
I'm
don't
saying is this, Ms. Lipscomb, you've already agreed that Mr. Miller, you reviewed a bunch of emails over the weekend. You indicated you didn't feel comfortable paying until the time of the hearing. You came in a couple hours beforehand. My question is, we all had a conversation, Ms. Lipscomb, about this.
Oh,
And
I
isn't
did
it,
not have a
let me finish the
conversation.
question, please. Isn't it true that all the parties collectively agreed that we were going to go in and ask Judge Cynthia Miller for a very brief adjournment so we could spend some quality time in preparation of defense? Yes or no?
I don't recollect that.
Okay, thank you.
Do not recollect.
Thank you. Now, Ms. Lipscomb, one of the things I'm confused about is this. After the hearing, you put on the record that you terminated Mr. Miller and Detroit Legal Group, correct? You didn't feel comfortable, correct?
Mr.
Yes or
Miller,
no? Yes or no? Yes or no?
repeat the question.
Did you fire Mr. Miller after the hearing? Yes or no?
I wanted to. He asked me to allow him, if I'm not mistaken, to go to, I believe it was it's all on flash drive. I can't exactly remember verbatim, but everything was recorded. So per
Do you have the
my,
recording? Do you have the recording right now?
oh, I sent you guys the recording as well as the honorable courts.
Ma'am, I'm going to be honest with you. I
No,
have
I'm
about
not lying to the courts, because
Ma'am,
everything, that whole conversation was recorded, sir.
okay,
You guys
okay.
have it.
Ms.
The
Lipscomb,
honorable courts have it. So he was not, I wanted to fire him that day, and he wanted me to wait, and I
Okay.
waited.
Ms. Lipscomb, my question is real simple. Did you fire him? Yes or no?
I wanted to on the day that I realized he was not suited for, or he could not properly represent me. The competency, as far as him understanding what was
Lipscomb,
going on,
Ms.
was a
Lipscomb.
problem.
The one thing I'm
Yes, sir.
not gonna deal with is the competency of my associates, okay? I am not gonna disrespect for you, and I don't want you to disrespect my associate, okay?
Competence is competence is an issue in this case, I suppose, but the central thing here is at this point is whether or not you fired him after the hearing. You said you wanted to, ma'am, but you did, correct?
Yes, sir, Your Honor.
All right, go ahead,
I
Mr.
did
Chair.
that.
So Judge, I missed that. Did she admit that she fired him?
She said that she wanted to, but she didn't fire him at that point. Is that correct,
Okay.
ma'am?
That is correct, Your Honor.
Okay, so let me ask you this, and I want you to remind you you're under oath, okay?
Oh, yes, I know that I am.
Ms. Lipscomb,
I'm a very
you
honest
said
person.
that Mr. Miller failed to attend the next hearing, correct?
Yes, he did.
Okay. Did he tell you that he was going to attend the hearing? Yes or no?
Yes, he did.
Okay. He told you that in a text message, email. How did he tell you?
I actually, everything I have documentation for. That's
And
in
why
the-
can't you testify to what happened? If you have
That-
documentation,
I am testifying to what happened.
Excuse me, Council, argumentative here, ma'am. Do you recall how it is that you received information that Mr. Miller was going to attend that hearing?
I believe there's emails, because I believe I emailed him asking him, why did he not show up or something of that nature. I was giving him the opportunity as he requested. It was something like that. I believe there is a form of an email.
ma'am, my last question is this. After the original court hearing on the 3rd, you recall having a conversation with myself, Ryan Hill.
I believe I called your firm. That's how you and I conversated.
So the answer is yes.
called you.
After all of that, the answer is yes, right?
Yes.
Okay, great. Ms. Lipscomb, we also have the ability to record phone conversations. Do you recall telling me verbatim that you were firing our firm on that day, April 3rd, that you were terminating our services and you wanted a full refund? Yes or no? Did you say that to me on the phone?
I believe that was after Mr. Miller, Attorney Miller, did not show giving him the opportunity to do what was right.
Okay.
And what was that date again, Counselor, that you referenced?
I'm saying April 3rd, 2023. Yeah. That's the date of the first hearing, Judge.
You're indicating, sir, that your question, you posed a question whether or not she indicated she called or it was a phone conversation where she stated that she was firing the firm as of that date. You're referring to the 3rd of April in regard to that question, sir?
Yes.
And I would have to recollect also to that exact date where I made contact with the firm when Attorney Miller did not show, giving him the opportunity to do what
There's
was
no
right.
question, ma'am. Thank you. Let me ask you this. On April 3rd, the hearing in front of Judge Cynthia Miller, how long did that hearing take? And that was recorded. That hearing was recorded. How long did that hearing take?
And I recorded it as well.
Yes or no? Just tell me the
And
time, ma'am.
I want to say probably about an hour or maybe about an hour or
An hour.
two.
Okay.
I want to say maybe an hour.
All right.
And I
So
provided that to you all as well as to the honorable courts as well. So I have nothing
Ms.
to hide.
Lipscomb, I just asked you how long it took.
Maybe about an hour approximately.
You came in on that Monday morning, April 3rd. You paid money and you and Mr. Miller prepared for the hearing, correct?
No, we didn't prepare for anything. I had already sent documentation, sir.
Okay, thank you, ma'am.
Yeah.
Did you just pay the money and leave, or did you stay there and actually have a conversation with our firm?
We had a conversation.
How long did that last?
I want to say probably it was unproductive on his part, maybe about 2
Ms.
hours,
Lipscomb, I'm not asking for the commentary. I'm asking for how much time?
approximately 2 hours, an
2
hour and
hours.
a half or two.
2 hours.
And that
So,
conversation was.
Thank you, Ms. Lipscomb. There's no question pending. There's no question pending. So I want to get this straight. Okay, I'm just going to summarize this. You call on Thursday or Friday before a Monday hearing, and you inquire about legal services, correct?
Correct.
Okay. You speak to Mr. Miller. You say for 20 minutes, all right? And you indicate that approximately, yes, approximately. And you start sending emails shortly after that conversation, correct?
As he instructed.
Yes or
me.
no?
Evidence.
Yes or no? Okay. He indicates to you that it's going to be a flat rate legal fee of $2,500. You say you agree, right? Correct?
He never stated the word flat rate. You're saying flat rate, and you and I had that conversation when I spoke with you.
Ms. Lipscomb, Ms. Lipscomb, Ms. Lipscomb.
You're stating, you're asking me a question, and I am responding to you, sir. You say flat rate, you did not say flat rate.
All right, that's your
I'm
testimony.
going to say yes to you on something that's not correct.
What's your interpretation of the retainer then? Explain it to the court, because you've already said you
I was
agreed to a flat
told
rate.
$2,500.
Excuse me, I cut you off, ma'am. The counsel, you're being a bit argumentative here. Let me.
Judge, listen, she is not answering. All I want is, I just want her to say yes or no.
She answered that question, but she says that the part where you said it was a flat rate, that that part was not included. Let me ask a question here, ma'am. Unmute yourself and let me ask you a question.
Yes, sir, Your Honor.
In the agreement that you signed regarding the $2,500, did it have an hourly amount?
And I'm sorry, Your Honor, that was something that I had a conversation with. There was never an agreement that was signed. And I inquired of an agreement.
Okay, thank you. Let me stop you now. So you agreed to pay $2,500, correct, ma'am?
Yes, sir, Your Honor.
Paid the $2,500, correct, ma'am?
Yes, I did pay the $2,500, Your Honor.
Was never a discussion about $100 an hour, $150 an hour, $200 an hour. There was never a discussion like that. Is that correct?
No, sir, Your Honor, it was not.
All right. So the reason that you're getting the question about a flat rate is because usually if there is an agreement between the parties and it involves proportional payments, it would either say you pay for this much service for X amount, or you pay X amount per hour. And that's why the question is, what did you understand the agreement to be? You didn't understand it to be an hourly fee because they didn't give you an hourly rate, did they?
No, sir, there was never a conversation about an hourly rate.
Okay. And they did give you a document regarding X amount to go to court, X amount to review documents, X amount to do whatever. They just gave you and that's why the question, they just gave you a flat rate and said, this is what it's gonna cost to provide that service. To the
Yes,
best
sir.
of your,
They
is
stated
that about the size of?
2,500. Yes, sir, just
Okay.
2,500, and I asked for
Judge.
like to
Thank you.
sign. Okay,
Yeah. That's the agreement. Go ahead, Mr. Hill. You can pick up
So-
from there, sir.
Okay, so you agree to pay the 2,500, you send the emails to Mr. Miller, and he reviews them over the weekend, yes or no?
no, he did not.
Thank
and
you,
I
thank you,
proved that
thank
he
you.
did
No,
not.
no is fine.
You asked me a question.
Yeah, I said
Yeah.
yes or no.
That's a yes.
He did not, no, he did not review the documents, and I have proof he did not.
Let's hear the question again. What was your question, Mr. Hill?
You agreed to pay the $2,500, sent emails, and Mr. Miller reviewed the documents requested. You said no, correct?
I'm sorry, you said it so quickly. Say that again?
Did
That's a
Mr. Miller?
Also, compound question, ma'am.
Sorry.
This question there, you agreed to pay the 2,500. You in fact paid the 2,500 at some point, but you began sending documents. And in sending those documents, did you anticipate that Mr. Miller would review those documents? That is
Yes,
true?
sir, Your Honor, because he told me
Thank
he
you.
would over the weekend.
Okay,
Thank
thank
you.
you, ma'am.
And
Thank you,
and
Jimmy.
thank you, and he said he was gonna review them, and you still hadn't paid the retainer yet, correct? Yes or no?
They asked that question. That's been asked and answered. The answer to that is yes.
Okay,
Let's move forward.
and that's all I have, Judge.
Thank you. All right, ma'am, we're gonna go to the other side in just a moment. Anything else you wanted to bring to my attention here, ma'am? It seems to me that what came out here, obviously, the parties may agree a bit about whether it was Thursday or Friday. Basically, what the inquiry was about was somewhere Thursday or Friday, there was an agreement to provide services that was to be paid for before going to court. That was paid sometime on the following Monday. Documents, there was a conversation. Documents were sent to Mr. Miller, and with the understanding that Mr. Miller was going to review those documents. And then ultimately, the parties went to court. In court, there was an adjournment that was requested, and subsequent to that time, there was another hearing coming up, and your understanding was that Mr. Miller would appear, but it seemed to me that you had already told them on the 3rd of April that you no longer wanted their services, that you fired the firm at that time. Is that about the size of what happened here, ma'am?
Actually, Your Honor, I did not, Mr. Miller asked me, and that's reported as well. Pretty much, he kind of didn't want me to fire him. He wanted me to allow him the opportunity to still represent me. I didn't feel right in my soul based on the conversation he had with Mr. Ryan. He seemed like he didn't know what to do, having everything he needed to properly represent me. Everything emailed, I was very thorough. I allowed him that opportunity, and yet he's failed again. He did not show. And as far as all the evidence that I supported, that I emailed to Attorney Miller, he never reviewed the documentations.
This has already been testified to repeatedly.
Okay,
What?
Stop you, ma'am.
I have the evidence
Ma'am,
to support he did not.
listen, you sent documents,
Yeah.
and of course, you can make by way of a closing statement or whatever at some point that you don't believe that he reviewed the documents. If you sent documents, all you can say is you sent them for him to review them. You don't know whether he reviewed the documents or not. You could draw a conclusion by way of argument and say that I don't believe that he reviewed them because when we went to court, he didn't seem to know what was going on or whatever. But ma'am, for you to testify that he did not review the documents, you can't. Really, you could say that you could say that 1,000 times, unless you could tell me that you were sitting there when those documents came through the emails, and he said, "Well, I'm not reviewing those documents." I mean, you can assume that in your own thinking that he didn't review them, but that testimony could never be sustained because you don't have anything No, you don't have anything that you can show that he just did not review any documents.
I recorded the conversation, Your Honor, between myself and Attorney Miller on that date of Monday, where I asked him, did he receive all of my evidence to support my innocence in the matter? And he stated verbatim on the recording, I didn't really have chance, I think his words were, I really didn't have chance to review. You said so much, I don't really know. And he's trying to go through it right then. At that moment,
Lipscomb, Ms.
I have a
Lipscomb,
recording.
play the
I have
recording
the
right now.
recording.
Play the recording.
Oh, we can adjourn it for the recording to be played.
We're
We
never
can
gonna adjourn.
adjourn this
That's what I
portion.
thought.
No, we're not gonna adjourn. We're not
You
gonna adjourn.
have,
I have to cut you off there. We're not gonna adjourn anything here. That's for sure. The fact of the matter is that, it sounds like in the best case scenario, if you have a recording that Mr. Miller says that he didn't get to review everything, that you sent so many things and et cetera, that doesn't mean that he didn't review documents that were sent to him. That doesn't mean that. But again, that's just a small part of this case. You sent a lot of documents by your own testimony, and Mr. Miller apparently told you that he may not have gotten to all of the documents. That may be a part of the problem in this case, and I'll address and weigh all of that. But again, to suggest that the gentleman didn't review any of the documents, I don't think that that's supported by anything here. Even if you got a tape saying that, well, I didn't get to everything. Of course, if you're sending stuff. And well, I just don't think that carries a whole lot of weight. Yeah, you can make the argument that he told you that he didn't get to see to review everything. I'll take that into consideration. Okay. All right. So, ma'am, I guess what I was getting at is that, what else is there that you want to tell me about? I know based upon the undisputed testimony that you agreed to hire the firm, you paid some money, that some documents were sent, that Mr. Miller says he reviewed some, didn't get to review all documents, and that when he came to court, the matter was adjourned. Mr. Miller's firm says that was the agreement, that the matter would be adjourned and then it would work on the details. That's in dispute. And then the other part of this is that you fired them on the 3rd of April. That's undisputed. But there's also some testimony that you wanted to give Mr. Miller a second chance, and he didn't show up at a subsequent hearing, which if you fired them on the 3rd of April, no lawyer is going to show up at a hearing after they've been fired. They can't charge you any more money, and they can't do any more work if you fired them on the 3rd. Even if there's some equivocation, they're fired. They're almost malpractice to show up and put their appearance on the record for you if you fired. So all of those things.
I
all
can't
those things.
exactly remember. Oh, I'm
Go ahead,
sorry.
ma'am.
One of the things that I would like to state to the honorable courts is that I requested of Mr. Miller, if I'm not mistaken, some type of like agreement or something. And if I'm recalling correctly, I believe he stated to me that when I come in on Monday to bring the $2,500 or something like that, that I would get that then. I never got that. So technically, when you hire a firm, there should be some sort of agreement in writing that the individual that's retaining the attorney.
Yeah. All right. So I believe that you testified that that you had an agreement for $2,500. You never discussed anything about an hourly rate or a per service rate. But you also testified, I believe, that you did not get the written document, or that it was sent to you later. What happened with the written document, to the best of your knowledge?
I'm sorry, say that again, Your Honor.
What happened regarding the fee agreement, the $2,500 document? What happened? Did you ever get?
I never got that, and it was never told to me that the $2,500 was non-refundable. That was never told to me. And in my entire recording from day one all the way through the end of the relationship, I do not have anything that states from Attorney Miller or Attorney Ryan that it was non-refundable. That was never told to me at all. And
Judge, I'll stipulate, Judge, I'll stipulate that there wasn't a fee agreement signed in this matter, just because of the time restraints, but I'll stipulate, and Mr. Miller will explain why.
All right, very well. Thank you, ma'am. And at this point, I'm going to allow this to go to Mr. Hill to examine and call his witness at this time. You may, sir.
Thank you, Judge. I'm going to call Mr. Miller to the stand. Clay, raise your right hand, please.
You do solemnly swear or affirm, sir, that the testimony you're about to give is the truth, so help you God.
I do.
You may at this time, counsel.
Mr. Miller, I know this is your first time testifying in court. I'm going to ask you to really listen to my questions. I know you're a little worked up right now. But yes or no answers. If you want to explain, I want you to explain, okay? Yeah, you have to say yes and no too.
Sorry, yes.
Okay, all right. So, isn't it true, you've heard Ms. Lipscomb's testimony. Can you tell the court what day she first reached out to Detroit Legal Group? Was it the 30th or the 31st?
It's my belief it was the 31st.
Okay. Let me stop you there. So that's Friday, March 31st. And how did she first reach out to the law firm? Was it a phone call, email? What was it?
It was a phone call.
Okay. And you took that phone call?
I did.
All right. How long did that phone call last?
I don't know exactly, but I know it went over an hour at least, probably closer to 2, and it did go beyond 5 o'clock. So it was quite a while.
Okay. So you recall, and this was on the Friday, the 31st, correct?
Correct.
All right. Is there a possibility that she called on the Thursday as well, or?
Possibly, but I don't think so because, as Ms. Lipscomb said, after we got off the phone, she immediately started sending emails. And the first email I have from her is dated on the 31st, and it came through at 9:08 p.m.
Okay, let me stop you there. So your testimony based on what you recall is Ms. Lipscomb calls sometime the latter part on the Friday, the 31st, correct?
Correct.
And she tells you what's going on. They're show causing her for not picking up her daughter, correct?
Right. I mean, there's a lot of moving parts.
Sure. All right. And you're saying here today under oath that the first email you received from Ms. Lipscomb was Friday, March 31st at 9 p.m.?
9:08 p.m.
Got it. Okay. And you've already testified it was a couple hours, the conversation with Ms. Lipscomb, correct?
Correct.
Did you give her a price in terms of what what Detroit Legal Group was going to charge for that?
Yes, we quoted the price of $2,500.
And how did you come up with that number?
I asked my supervisor, you.
You asked me. Okay. And did you explain to Ms. Lipscomb this was a flat rate, an hourly rate? What did you say to her?
I explained it was a flat rate and this would be for the duration of the case. There would be no hourly billing.
Did you explain to her that eventually she'd have to sign a fee agreement?
Yes, I did.
Okay. And what if anything happened between, we'll strike that. How many emails did she send starting on Friday at 9 p.m. to Monday when she came in? How many, roughly, give me an approximation.
Approximately 50 or 60.
Okay. And do you have them up on your screen right now?
I do.
Can you, Judge, can you just allow Mr. Miller to share screen? I'm not going to go over every email, Judge. I'm just going to show that they were received. That's all.
What already is now.
I have the ability to do that.
Okay, sorry.
Okay, can you see it?
Yes.
Okay, down here, you'll see this is the first one dated 3/31, 2023 at 9:08.
Hang on. I'm looking here. It says, oh, that's forwarded, March 17th. It's forwarded. Okay. Show, and I can't see this. March, okay, right there, March 31st, 9:08. According to at least your inbox, that's the first email you got?
Yeah.
Okay, and scroll up.
So you can see these are the more emails coming through later that day, that evening. It keeps going. I received several that day, but then on the 1st, there were more coming through at 12:11 a.m.
Okay, leave that on there, okay? And that's just I'm not gonna go over every single one, but you received all these emails over that 2-day period, and they usually had they had attachments to it, correct?
Yes, they all had several attachments.
Okay, in your conversation with Ms. Lipscomb on that Friday, did you tell her the price?
Yes,
Did you tell her that we would appear in court without paying the fee?
no.
What did you tell her, if anything?
I said that we would need to be paid before we show up. And the initial plan, I sent an invoice that Friday at like 8 or so.
Can you pull
before-
that up if you can, if you can find it?
I can find it. It's right here, actually. Right here is the very first bill I sent to her for 2,500. This was at 5:30 that day. So this would have been shortly after we, I'm not sure if I sent this to her while we were on the phone or shortly thereafter, but I remember I sent this.
All right, and she acknowledged receiving the bill, correct?
Yes.
Okay, and did she pay the bill that Friday?
No, that was the plan, but no, she didn't.
Did she tell you that she was gonna pay the bill over the weekend?
Yes.
Okay, but obviously you agree with her testimony. She didn't pay until the morning when she came into the court or our office, correct?
That is correct, yes.
Okay, now she sent several emails and Miss Lipscomb indicated that she has a voice recording of you saying you never reviewed it. Is that true?
No, it's not true that I did not review them. I did review them.
Can you explain to the court what you told me earlier in terms of your preparation for the hearing in anticipation that Miss Lipscomb was going to pay?
As you can see, it was a lot to take in, and each one had a bunch of different attachments. And so as I was going through all of these emails and attachments, it was just a lot. I was starting to see like some duplicate attachments, and
Got one for me.
I looked through it, but it wasn't painting a clear picture because it was so extensive.
Click on one just so that the court can see, please.
So here's one.
And Judge, you know what? You know what, Clay, hang on a second. I don't want him to open up anything that might be under HIPAA or attorney-client privilege information. Unless Miss Lipscomb, did she provide all these documents to the court already?
I did. Everything
Okay, thank
was
you.
provided to the honorable court.
Okay, so go back to the other one, right there.
So
Alright,
this
so-
one,
So this is, and it says was sent to CPS higher ups. This is, and I don't want you to get into the details, but is this a typical email that you would see from her that you reviewed over that
Yeah.
weekend?
exactly.
Okay, all right. So I guess is your testimony that you reviewed as much of it as you could, but you started seeing duplicates? Is that accurate?
I reviewed as much as I could, like actually just hold in my brain. I mean, there was just so much, and it was getting very confusing and difficult. And then when you see the duplicates, it just made things even more confusing. I didn't know if I was missing something or what. So
Okay,
That's-
let me ask you this. Is there an office policy to actually perform work, which it seems like you did without being paid? Yes or no?
there's a policy against it. If anything, I'm not supposed to do that.
Okay, all right. All right. But it seems like you reviewed the hearing because you thought Miss Lipscomb was going to pay, correct?
Correct.
Okay. Was I happy that you strike that? Okay, so did you ever have any communication between Miss Lipscomb between that Friday and the Monday, whether it be not email, but text messages or voice call, phone calls?
You know, I honestly don't recall. What I do recall is getting a phone call, or maybe it was an email, but I got notice from her saying that she wanted to pay upon arrival at the court.
Do you have
And
text messages from Miss Lipscomb?
I don't recall. I've got a new phone since all of this.
No problem. Okay, so and then you indicated to her, what did you indicate, if anything, when she asked to pay the court?
I indicated that we can't show up without being paid.
She came in and paid, correct?
So yes, she came down to pay, and then we discussed the matter for a couple hours. It was 12:30, an hour before the hearing, and I basically told Ms. Lipscomb, we got to go get lunch, and I'll see you at court. We got to like get ready for this thing.
So
So-
you prepared for a couple hours prior to the hearing, correct?
Correct.
And as far as you know, Miss Lipscomb was aware that we'll strike that. What was the intention of the hearing? What did you discuss with Ms. Lipscomb in terms of strategy for that particular hearing on the 3rd?
So for that hearing, the strategy was essentially to get an adjournment so we could wrap our minds around everything and go through the details a little better for the defense, and because of the time constraints we were under.
Okay. And Ms. Lipscomb understood that and she agreed to it?
Yes,
Okay. Now, the cause of action was a show cause for her failing to pick up her daughter from a facility. Is that accurate?
that is accurate.
Okay. And how long did the hearing actually take in front of Cynthia Miller?
The hearing took a long time. I would say it
You
was
broke up there.
over
How
2
long did it take?
hours, and
Lost your voice.
maybe
I
even
can't hear
3,
him.
because
I'm
there
sorry,
was
I
just so
can't
many
hear
moving
anyone.
We
parts
can't hear
going
you.
on
We can't hear
at
you.
that hearing.
I can't hear. I can't hear.
Yeah, no one
Yeah.
can.
I
Clay,
No one.
We can't hear you.
Mr. Miller?
Can you hear me now? I
Yeah.
haven't changed.
now I can hear.
Okay, how long did the hearing take?
It took at least 2.5, maybe 3 hours. It was a long hearing.
Okay, and your request was just for an adjournment. Did you explain to Judge Miller why we were requesting the adjournment?
Yes, yes. And
Okay.
she granted our adjournment because she understood that we were just paying.
Okay. And did you discuss on the Monday, and if you didn't, that's fine, but did you discuss with Ms. Lipscomb that eventually after that hearing, she was gonna have to sign a fee agreement?
You know, I know I mentioned it to her at some point. I'm not sure if it was discussed on the Monday or not.
Okay, okay. And is there a reason why on that particular day, on Monday, you didn't make it a priority to get the fee agreement signed?
I had her in my office. I was prioritizing the case in case we didn't get an adjournment granted, because if
I
an
see.
adjournment was not granted, we had to be ready to defend her from show cause.
I get it. Okay, so after you get the adjournment, what happens after that?
Well, what specifically are you asking about? Because like the hearing
Ms.
itself,
Ms.
or with the-
Lipscomb indicated that she had a conversation with you. Do you recall that conversation?
yeah, she was extremely upset, furious with me because I did not. She was wanting me to argue the merits of the show cause defense, and we had got the adjournment granted pursuant to our plan, and so she was wanting me to argue after the adjournment had been granted the defense of the show cause when it wasn't the time or place for that, and I didn't do that. So that's why she.
So is it your testimony that Judge Cynthia Miller granted the adjournment, but she still wanted you to place in the record her defenses?
Essentially, yeah, she wanted me to argue the case.
Okay, did she fire you in Detroit Legal Group that day, if you recall?
I know she discussed it, she wanted to, but I do believe it was a couple days after, because as she alluded to, we talked and I said, I wanted to do right by her at the end of the day. So I was trying to help her. I didn't want it to, go sideways, but I think it was 2 days after.
2 days after, and then she contacts the firm. Who does she speak to? Does she speak to you?
Yeah,
And she indicated she no longer wanted Detroit Legal Group's services, correct?
yes.
Okay, we provided in our answer a Clio invoice, an hourly billable invoice 00185 Lipscomb. Are you familiar with that document?
I am.
Okay, and what was the purpose of that document if this thing was a flat rate? Why did we submit that?
So we could show the hours that we had on it. And I mean, we were just trying to do right by Ms. Lipscomb after she had fired us. She wanted a full refund. And you told me to basically calculate my hours and figure out what we had into it. And we offered her a refund accordingly.
And the exhibit that we attached breaks down those hours. Are those accurate hours that you worked on the file?
They're accurate, but it's not everything. But
It's
yeah,
not everything. Okay, so there is some things on here that you spoke to Ms. Lipscomb after that aren't reflected in this invoice, correct?
correct.
And your billable hourly rate is $225, is that correct?
At the time, yeah.
Okay, and taking into consideration the hourly rate, what if any refund did we offer Ms. Lipscomb at the time?
I believe we offered her $1,000 back.
Do you know how, did she fire us via email or was it on the phone, if you recall?
I think both. I think it was first on the phone, but I think she sent an email confirming or.
Okay, you heard Ms. Lipscomb testimony previously on the Thursday or Friday that the conversation, the initial one was only 20 minutes. Is that true?
That's not true.
Okay. I don't have anything further, Your Honor. Ms. Lipscomb, your witness.
All right, Ms. Lipscomb, you can ask questions of Mr. Miller at this point, if you wish, ma'am. Go ahead.
Okay, yes, sir, Your Honor, I would. Mr. Miller, you're in your testimony, you mentioned that, you mentioned to me about a flat rate in regards to the $2,500 being so. When did you mention to me about a flat rate? And at what point? Is it when I hired you all is it at the point when I retained you all? Or was it at the point when we were in your office on the date of the hearing?
It would have been on when we were on the phone talking before you retained us. When you were
Okay.
talking about it, because
Your Honor, am I able to state that that was never stated to me about a flat rate?
I think you knew the answer to that before you asked. The only thing you can do here is ask questions.
Okay. Did you mention anything to me about a fee agreement of the $2,500, putting it in the form of writing? Whether it's
yes,
a flat rate or whether it's
Ma'am,
being hourly.
question is pretty straightforward. Did you mention anything to her about putting the fee agreement in some written form?
yes, I believe I did.
And
At what point?
And at what, okay, I was gonna, did you mention that on the date that I was in your office?
There's
On
a
the
question. There's a question. At what point did you mention that there would need to be a written document regarding the agreement?
Likely at the beginning, on the Friday when we spoke, and as well as when she was in my office prior to the hearing. If I could just expound a little, again, the fee agreement was not my main priority at this point because I was
I believe
preparing for.
that let me stop you. I believe that you testified to what was your impetus in that you had received notice of a case and there was a hearing that was pending. All right, sir. Your next question, ma'am.
Did you not explain to me, by phone? I'm sorry, did you not mention on
Your sound went
the
out,
date of
ma'am.
our hearing while I was in your
I'm not
office
hearing you now. for some
that
reason.
you did not have enough
Yeah,
time
still
to
not hearing you, Ms.
review,
Lipscomb. Ms. Lipscomb, Ms.
the
Lipscomb,
emails
I'm
or the
not hearing
evidence?
you. Yeah, not hearing you. Something happened where your sound went out. Okay,
Oh.
You're back.
your next, yeah, ma'am. What was your question? Because
Okay,
I don't know what it was. Just like when Mr. was testifying, the sound went out. I didn't hear anything. So go ahead with your question, ma'am.
okay, on the date that I was in your office, which was the date of the hearing, my question is, I'm sorry, did you not mention that you had not had the opportunity to review my evidence to support my innocence? Did you not mention that there was a significant amount of emails that had come forth and that you
Objection,
did
compound
not,
question.
I'll
did
sustain
not,
the objection. I'll sustain the objection. Yeah, you're making your question a little bit too complicated by adding too many parts. Your question is whether or not he told you at the office that he did not have time to review all of the documents regarding your innocence. That's your question, correct?
yes, sir, Your Honor.
Mr. Miller?
I would say I maybe acknowledged not reading every single word of every single attachment and every single word in every email. So I didn't look through every single thing perhaps, but I did go through as much as I could for as long as I could over the week.
And did you not inform me that you would review everything and be prepared to represent me on that Monday? Did
I
you
did
not?
indicate that I would prepare over the weekend and review everything. I'll admit I wasn't expecting so much, but I did indicate that I would, and I did.
On the date of the hearing, did you not state that you didn't know what to do?
I
with the-
did state that, but I'd like to clarify the context. As you may recall, Ms. Lipscomb, when we got there, there was representative from CPS, there was representative from Wolverine, there was representative from another facility, and us and the attorney for the state. The issue that we had that I didn't know I was getting into or didn't know the extent of is that the daughter, because she was not picked up by Ms. Lipscomb, she was basically in danger of being sent to another juvenile detention center, which nobody wanted her to go to because it got a bad reputation. The one that she was currently at was closing. Okay, so when I got there, I was talking to the CPS workers, I was talking to the representatives from these facilities, and they were basically telling me that, no, yeah, this place is closing. Like, we got to figure it out, right? So she couldn't stay where she was. They didn't want her to go to where she would be sent if they didn't resolve the show cause issue. And so at that point, I said, I don't know what we're going to do, in the sense that how we're going to manage all of this and figure out what where to send the daughter, because the place she was at was right. So that's the only thing I didn't know how we were going to handle. I knew exactly what I was doing in terms of the hearing. I just didn't know how we were logistically and practically going to resolve the issue with the daughter and the being closed.
Okay, so let's touch on that a little bit. So everything that you just stated right now on the record, did you not have evidence that was supported to you of the fact that the CPS case was dismissed against me for negligent?
Judge, I'm gonna, hang on, Ms. Lipscomb, I'm gonna object this line of questioning. There's already testimony that the sole basis for the hearing was for an adjournment. So anything as it relates to the merits that were addressed
Actually,
after, I don't.
can ask him.
Can I finish, Ms. Lipscomb? Let me finish. So anything,
Excuse me, when someone objects, you have to be quiet, because I decide, once somebody objects, the court has to make a ruling on that objection, right? So that's why I shut you down, set it up, you come back in, you gotta wait. Go ahead, sir.
So Judge, my objection is, I guess, twofold. It's not relevant. Mr. Mallory testified that the basis for the attending the hearing was to get an adjournment. It lasted a lot longer than he thought it would. But everything else as it relates to the merits, we didn't argue, therefore it's not relevant, and it's not relevant to the fee dispute that's at hand, in my opinion.
Well, I think that you're partially correct regarding relevance on this issue. There's a disagreement, it seems, in this hearing about whether or not this the issue to be pursued was an adjournment. As I understand the case, there's some bifurcation here. Mr. Miller deemed that the most appropriate thing for him to do was to acquire an adjournment of this hearing. And obviously, Ms. Lipscomb wanted him to argue the merits. He did not believe that that was the appropriate thing to do at that time. That's my understanding. Now, Ms. Lipscomb, I'm not going to allow the parties to get into the merits of this. It's obvious to me from the testimony from both sides in this matter that a voluminous amount of materials was sent over a short period of time for a hearing that was to occur within a short time of the initial representation. I don't make a finding on this, but it makes sense to me that if a lawyer receives that much information in a short period of time, and there is a show cause hearing that could have consequences to a litigant's life and reputation, that being able to stop everything in its place until the parties are ready to go forward with the best arguments that they make. That does not seem like an unreasonable approach to take. But parties can disagree about that. That doesn't seem to be unreasonable. If you're coming into a hearing with voluminous information regarding the life of a young lady and the number of issues that comes up when there is a factual statement that Ms. Lipscomb has been directed to pick the child up and did not pick the child up, that could sound like an issue for show cause. That could get her in a bunch of trouble, even if she's right on the merits. The fact that she has a show cause means that that judge could send her to jail just because she didn't pick the kid up, not because she's a negligent parent, not because she's a bad person, but because there's a show cause. And a lawyer getting involved in that will want to make sure that his client is not going to end up going to jail on the show cause when they can live to fight another day. But ma'am, I'll allow you to continue with your inquiry, but again, we're not going to get into the particular merits of the case. If you wanted to argue the case yourself, then you shouldn't have hired a lawyer. Because when you hire a lawyer, they're going to make some decisions about how the case goes forward as well. So go ahead with your questions. I may have to stop you if they're delving into stuff that doesn't, that's not going to be relevant to this hearing. Go ahead, Ms. Lipscomb.
Thank you, Your Honor. One of the things that I would like to ask Attorney Miller is, did he state to me, well, I think he did answer that question, that he was going to review everything on the weekend to be prepared to represent me. However, my next question is as follows. Why is it that you, Attorney Miller, did not state to me, why you didn't talk to me as your client and say, I've went in, I've had a conversation with people, with the state or what have you, and then have a conversation with me. I do see we need to have an adjournment, and this is why. Why did you not relay that information to me?
I did multiple times. I did it. That was our plan here. You watched me talk to everyone in the court hearing. I did. So yeah.
Okay. My next question, I'm not going to argue with. So my next question is, one second. Did I not report documentation to you and was very thorough in letting you know why I did not pick up my daughter, and that CPS had dismissed the case?
Judge, same objection as before. It's not relevant.
Well, he mentioned it, kind of downgraded me as a parent. He mentioned that I did not pick up my daughter, and he was aware that my daughter was not in her same mind.
Ms. Lipscomb,
were you not aware of that, Attorney Miller?
Ms. Lipscomb, the whole, I have an objection. I have an objection.
I am both in the nursing and education profession. He would not downgrade my credibility, and he would not downgrade me as a parent. So I'm asking Attorney Miller, was he aware of the fact that my daughter was not in her same mind and that she was taking off all of her medications at that facility?
Judge, I place an objection.
Now, ma'am, that's the last time I'm gonna let you go off the hearing. You can't do that. You're an intelligent lady. You're educated. You're a professional. I told you before that when you hear an objection, you don't have the right to then just start talking. When it says objection, it's my turn to they get finished talking. I told you that before. I let you ramble on and on this time because I want you to see. I want you to see because I think you're intelligent. I think you're an educated person. I want you to see how cumbersome that becomes on this hearing. Which, by the way, when you start doing that, ma'am, I'm not giving that any attention because you're out of order. None of that means. And you already told me previously, you've already testified to much of what you're saying about your daughter. You want everybody to know that you're a great parent. I have no reason to doubt that. You told me you have 5 children. You told me that this particular young lady has mental illness problems and what have you. Listen, I have 6 children. I am grateful beyond measure that I have not had a child with mental illness, but I've dealt with families that have children with mental illness, that have children with incorrigibility problems. That's not something that you created. That's a world that exists out there. People go through stuff like that. That's not what this case is about. You send a bunch of documents to a lawyer begins to take a look at those documents. His objective is the same objective that you have, but he's looking at that a little bit differently. You're looking to prove that you are a parent. I'm not making a finding here, but you're looking to prove that you're a great parent. He's looking to make sure that a judge don't get it wrong on a show cause and send you to jail. That's what he's looking at. You want to prove right then and there that you're a great parent. Nobody, I don't even think that, I know he's not questioning, I'm not questioning that. My God, if you got the opportunity to raise other kids and you got to deal with a child that you've done your best with, but yet they struggle with all kinds of stuff, and then you got to find the right medication, and they put them on one medication, then they're down too low, put them on another one, they're up too high, all kinds of stuff like that. Yes, I've worked in the mental health field, and yes, I've dealt with a lot of people that suffer various mental illnesses and what have you. It's a tough one, well of a journey for any parent to deal with if they have one child, let alone 5 children. But that's not what this case is about. What this case is about is that someone has issued a show cause because you specifically did not follow an order that says pick a child up. Now, maybe you have reasons for that, and your lawyer is going to articulate what those reasons are at the appropriate time to do that. But the issue is that now you have a judge that's issued an order that says this person should go to jail or be given some kind of penalty because they didn't follow a court order. That's what this is. And whether you disagree with the style that one person takes or another, that's okay. People can fire their lawyers. They can decide that I don't want you to do it anymore. I don't want you to handle the case anymore. And that's what this case comes down to, is that you had a disagreement. You don't like the way that they approach it. I'm not saying I would have done it the way that Mr. Miller did it. I'm not saying that another lawyer would do it that way. But I'm saying that some lawyers would handle the case by saying, if we can go in there when we've got a voluminous amount of documents and get an adjournment, we consider that a win, because our client is not being sent to jail or fined or something along those lines for specifically not following a court order that says pick a child up. So that's what this case is about. So when there's an objection, the objection is that judge, in this particular instance, the objection is judge, she's going into some particular details about the nuances of our parenting and so on. So, and that's not particularly relevant to this case. It's not. So, ma'am, you can still ask questions, but your questions got to be pointed to the issue that's before this court regarding the propriety of the fee that was charged and whether or not there is some amount that would be coming back to you. That's what this case is about. The fact that you disagreed with Mr. Miller's approach to handling the case, that's axiomatic. You wouldn't be here if you didn't disagree. You wouldn't have fired him if you didn't disagree. But a disagreement does not make incompetent a lawyer. It does not evaporate the work that a lawyer may have done on the file. But there's a lot of things that I can take into consideration. So, ma'am, I want you to go ahead and ask him questions about stuff that is relevant to this case, if you have any more questions. If you don't, that's okay too. And then you get to go to argument, and I'll get to hear both sides argue this and tell me what they believe that the case has shown. If you have other questions for Mr. Miller that are relevant, ma'am, go ahead with your questions.
Thank you, Your Honor. So my next question is, Attorney Miller, were you not aware of the fact that this was in regards to a show cause hearing, that I didn't even know about the show cause? First of all, I didn't know that there was initially a show cause hearing. Did I bring that to your attention that I happened to call the courtroom and was told that I had a show cause hearing? And I didn't know.
I don't know what the question.
I'm going to object to relevancy. I think she's trying to state that she didn't know about it, but how would we know about it? I'm confused.
Yeah,
Okay.
so you made me aware of it.
Okay, so were you not aware that I called the courtroom to find out if the hearing was going to be on that said day, to find out that there was a show cause hearing against me? Like, I didn't know that there was a show cause until I called the courtroom. And this was like way before I think I hired your firm.
Well, let me address that. Let me just, I mean, obviously, let me stop. No, it seems to me that what the question you're asking him is something that's intuitive to you and to us. You went and found out what was going on with the case and brought that information to Mr. Miller.
That's what I did.
Okay, yeah, I mean, I think he agrees with that, correct, Mr. Miller?
Sorry, agree with what?
Apparently, she went and found out what was going on with her case and brought that information to you for you to get involved in. To the best of your knowledge.
Yeah, that's how it goes.
So I guess what I'm trying to say is you knew that there was a show cause hearing. Once I found out, I informed you. Once I hired you, and I sent all the evidence for you to be able to support the fact of me not only not being negligent, but the fact that I'm not guilty of not showing, I'm sorry. I think there was, if I'm recalling correctly, the show cause was before. So there's a show cause hearing for example, today, but there was a show cause put out on me before that hearing. It was something like that, right? And I wanted you to.
I can't hear you. Sorry, there you go.
Let me say, there were some previous hearings that Mr. Miller was not involved in. At the time that you asked Mr. Miller to come involved in this case, there was already a show cause that was issued. And his retention was to deal with the show cause. So if you're asking about the history of the case, I think that you brought the history to him and told him that, hey, whatever happened before, there's a show cause now that I got to appear for. And of course, he knows what a show cause is. The show cause means that if the judge determines that you didn't follow an order, it don't have anything to do with how good of a parent you are. If the judge finds out or concludes that you did not pick that child up, that judge could send you to jail, a whole bunch of stuff. So that's what you hired him to do. And he went to court, or whatever happened is what happened here. Fortunately, with the show cause being adjourned, of course, that means that no action is taken on it, that you're not being sent to jail, you're not being fined, you live to fight another day. Go ahead with your next question. I think everybody understands where the case comes from.
So I guess the reason I asked that question is because I was asking Attorney Clayton Miller, and did I not ask you if you could let the judge know I had just became aware, I wanted you to speak in my behalf, that I had just became aware of the show cause hearing, but I didn't run, I was there, I did what I was supposed to do because, well, my client is innocent, she has nothing to hide, we had this conversation, right? And I asked if you could let the judge know she's not hiding, she's not running. The moment she found out from the courts that there was a show cause, she's here. Like you didn't go into the courtroom and do that. Like you didn't speak in my behalf is what I'm saying. Did I not ask if you could let the judge know that?
That's a long question. That's a long question. So I'm going to let him answer the question of whether or not he told the judge that. But ma'am, I'll say this. The fact that you were there with the lawyer means that you're there to deal with the case. Just the fact that you're there means that you have shown up, that you're not a slacker trying to run away from something, that you're here to deal with this. Now, he can certainly answer the question about whether or not he went before the judge and said, my client is here, she's not running, she's not. Well, answer that part of the question, Mr. Miller.
I don't remember exactly what I said. I'm sure that was part of my argument for seeking an adjournment. You know, I got
You
the
don't know, Clay, you don't know.
I don't know.
I guess what I'm saying is that you win on that argument. You went on that argument all day. I mean, unless the judge got up there and said, your client is a slacker and I'm getting ready to send her to jail. This lady is terrible. And then if your lawyer stands there and says, well, judge, I don't have nothing to say about that. But if you're there with a lawyer and the case, and he gets an adjournment for you, that right there shows that you're there to contest the issue, that you're not there saying that I did something wrong. You're there contesting the issue and saying that I want to have my rights validated here on the show cause thing so that the judge is not trying to send me to jail or something. So I don't get the point there, whether he said something or not about that, because you were there.
I guess the point now that brings me to say this. Attorney Clayton Miller came out and said to me, I'm playing with the state. I didn't pick up my daughter. His whole
You gotta hold on a second. All right, so your question is, did you tell me at the hearing that I was playing with the state because I didn't come and pick up my daughter? Is that your question?
and that I can't keep toying with the state, and that
Well, that's a question at a time. You understand the first question?
Yeah, kind of.
Whether,
Right.
whether or not, excuse me, whether or not you told her that she can't keep playing with the state and that she's in violation because she didn't pick up her daughter. Go ahead, sir.
I don't recall saying that. I might have. I don't know.
and I'm sorry, Your Honor, it's recorded also. So my position.
I don't care about the recording. Sir, if you told her that she's in violation because she didn't pick up her daughter or she can't play with the state, why would you tell her something like that?
Right.
Ma'am, that's a question. Why would you tell her that?
What's the question exactly? I'm sorry.
Why would you tell her that she can't play with the state and not pick up her daughter, that by not picking up her daughter, she would be in violation of a court order? Why would you tell her that?
Why would I tell her that she would be in violation of the court order? Because she would be if she didn't pick up her daughter. I'm not sure if I'm understanding.
You answered it, Clay.
Yeah, I mean, I can understand, and if that's your answer, and I'll allow other inquiry. Listen, I can understand if a lawyer tells you that you can't play with the state. If they tell you to do something, you got to do what they tell you to do, because a show cause means that if you didn't follow that court's order, that you could end up in a whole lot of trouble not following that court's order. Even if the lawyer is going to defend you and going to protect you and make sure that nothing goes wrong, you'd be a fool not to tell you that. Because a show cause means that you could go to jail. A show cause means that something has gone miserably wrong. And even if you are right about the case ultimately, if a judge issues an order that says, listen to me, if a judge issues an order that says, pick up the child by such and such a day, and you don't pick that child up, that's contempt of court. There's a show issue. Now, that doesn't, fortunately, this came out right, but that doesn't mean that you're a slacker. It means that something went wrong, and whatever went wrong in that regard, ma'am, that went wrong before Mr. Miller got involved. Whatever went wrong before he got involved. A show cause got issued somehow. Maybe it was issued by mistake. But if they told you to pick the child up and you're communicating that it's not safe to do so, listen to me, unless somebody issues an order and says, we agree that it's not safe for you to pick the child up, you're not picking the child up is a violation of a court order. And that causes the issuance of a show cause. And if you have a lawyer, your lawyer is going to inform you that the reason that they issued this show cause is because you were ordered to pick up the child and you didn't pick the child up. You can say, oh, well, I had this reason, but your lawyer will have to tell you that, whatever reasons you had, that court issues an order for you to pick that child up, that could send you to jail. That could get you in a whole bunch of trouble. Now, I don't know all the tenor of it. I know that Mr. Miller's testimony is that if he said something like that, he would have said that, informing you that a show cause for not following the court's order is something that could send you to jail. But that's why he would have told you that. Now, I don't think they're telling you that, not based on everything I'm hearing here. I don't believe that telling you that was saying you're a horrible, bad person and what a terrible person you are. I don't believe it was that. I believe that is him. It sounds like what he was telling you is that this is what we have to deal with, because this court can send you to jail for stuff like that. Now, should they send you to jail? They should. Did you go to jail? Fortunately not. Apparently the show cause was dismissed at some point. I think it would have been dismissed at any point, because I think that when the nuances of your daughter's mental illness, harm to herself, potential harm to others under the mental health code, when all of that came to the forefront, they didn't have any choice but to dismiss the show cause against you, because this is never about you, but because you're the parent, because just like if it was me, because you're the parent, even if the child is in the system, if they have not become a ward of the state, if you're still the parent and you still have parental rights, then even though somebody else got your child, guess who's still responsible? And you're responsible in a situation where you're trying to do the best that you can do because you are dealing with a child who through mental illness has displayed incorrigibility and potential harm to herself or to others. And that brings her within the mental health code. But when she comes here, you're still the parent. If they direct you to do something, you're going to get a show cause if you don't do it. That's what this case sounds like, the underlying case, not this case about fees. Okay, I'm gonna give you a few more minutes. If you want to ask any more questions of this gentleman,
Okay.
then you can ask questions. The parties get to the argument.
Thank you, Your Honor. So my overall questions were geared toward Attorney Miller was very much so aware of the logistics of the case. He knew pretty much everything from the time of our phone call, and I speak pretty fast but clear and very thorough, all the way up to the time frame that we were in his office. And he knew about the show clock, he knew everything, but he stated that I'm bringing up to the honorable courts as to what Attorney Clay Miller stated on the record.
Judge,
today.
I'm gonna object.
To the
Ms.
court.
Lipscomb, hang on a second, please. I'm gonna object. She's making a statement, not a question. This is more appropriate for closing arguments.
And I understand that you're not a lawyer, and that's how we have to break this up. This is your opportunity to ask this gentleman questions. I have heard your testimony, and I've heard some of the summary that you're giving about Mr. Miller's awareness because of documents that you sent to him, how he understood the case. But right now, the only thing that you can do with that is ask a question or ask questions. You could ask a question like, Mr. Miller, based upon all of the information that I provided to you, based upon all of what you knew about this case, why did you do this? Or why did you do this? Or did you think to do this? Okay, you could ask a threshold question like that if you want to, but you can't just go on and on about your summation of things. I'll give you a chance to do that before I issue a ruling in this case. Mr. Hill will have an opportunity to do that, and you'll have an opportunity to do that. That's called closing argument. Okay, so any question asked Mr. Miller at this time?
Thank you, Your Honor. Attorney Miller, my next question is, based upon all the information that you have in the cases, verbally, mainly verbally, and then second to that would be all the emails. My question is, why did you make those comments to me as if you felt you could not represent me?
Judge, I'm gonna object as to it's being compound, and I think we're getting back to what she's talking about, the bad parent thing, which I think the court's already
No, it's
addressed.
not. No.
Can you specify them?
So my
As to the form of the question, I'll sustain the objection. I think your question is simply this. Based upon everything that you knew about the case, provided by documents otherwise, I guess Ms. Lipscomb is asking you, why did you elect, or why did you choose to say something to her at the court regarding playing with the state or violating a court order and things along those lines? You understand the question, Mr.
I think I do.
That's the answer.
Any of those comments that would have been made about playing with the state and stuff, it was just trying to help her understand the severity of what could happen if she's found guilty for the show cause. It wasn't anything directed towards her bad parenting. And I want to say this, Ms. Lipscomb, I've always thought you were a great parent, which is why I took this case and worked so hard and fought to try to keep the relationship good. So I want to make that clear. But ultimately, that's the only reason I was saying those things, is to help Ms. Lipscomb understand the severity of it, because I don't know if she fully did understand, because she wanted me to make these arguments that, frankly, it wasn't the time to make those arguments. So anything stated in regard to playing with the state or anything like that was just for the purposes of making Ms. Lipscomb aware of the severity of the situation and the possible consequences.
All right, Any further questions, Ms. Lipscomb, as we move on?
Your Honor, you mentioned that there was a severity amount of hours that you put in toward the case, correct?
I did put hours into the case, yes.
Okay, so per our phone conversation on the date in which I did retain your firm, can you state for the record how long we were on the phone? Because I recollect approximately 20 minutes.
Judge, objection asked and answered already.
That has been asked and answered, ma'am. I believe that the witness has testified that it was in the nature of 2 hours or so for that discussion. I've heard your testimony as well, that it was 15 minutes. So
About
what is it?
15 minutes.
You already testified. I've got that testimony. All right, go ahead. Question.
And then my next, thank you, Your Honor. And then my next question is, on the date that I came into your office, I did mention that I wanted to bring the payment to court because I wanted to avoid hours. I know how this works, and I didn't want unnecessary fees passed.
What's your question? What's your question?
All right, Your Honor. So my next question is, how long were we in your office discussing, me trying to discuss the case with you?
Same objection, Judge.
I believe that the witness's testimony was that there was a 2 hour, 2.5 hour period in the office prior to the hearing and getting ready for the hearing. I believe that's the witness's testimony. Is that correct, Mr. Miller?
That's correct, Judge.
Yeah, that's been asked and answered. That's why we went about it that.
Oh,
in that
okay.
way.
Okay, so you don't, okay, Your Honor. So you don't agree that it was approximately 2 hours, maybe an hour and a half? Attorney.
I'm sorry.
I agree it was an hour, 2 hours, 2.5 hours, not 15 minutes.
No, we're speaking of the date of the hearing. We've already talked about the phone call being on, I believe was about 15, 20 minutes. We're talking the date of the hearing where I came in to pay you the $2,500.
Right.
My question,
Mr. Miller, I believe the testimony regarding when she came in to make the payment and before the hearing that the payment was received and you were focused on the hearing and it was, I believe you testified it was two hours or so before the hearing that you were trying to prepare for the hearing. That was a 2 hour period of time or so. Is that correct, sir?
Yeah, that's correct, Judge. She showed, I don't know when exactly Ms. Lipscomb came into our office. It was around 9:30, maybe 10, but I know at 12:30 is when we split. So it was a while.
All right.
so you don't agree that it was maybe about an hour and a half or two, not 2.5 or 3?
Hour and a half. I don't know.
The testimony is what it is on that point. Move on, man. Let's go forward. Any other questions?
So altogether, would you agree that the time frame that, well, I want to go backward a little, well, yeah. Did I not ask you while we were in the office on the day of the hearing, if you could make contact with certain agencies such as CPS to support the fact that the negligence case was dismissed, and you told me no? So,
Same objection as before.
I'll sustain the objection on that, ma'am.
okay. I guess where I'm going with this is that you made no phone calls in my behalf. I guess I can ask that question. Did you make any phone calls in my behalf?
On the day, ma'am?
I'll answer.
Sorry.
Well, I can't hear.
Oh, all right. Listen, I understand. Here's what I understand the question to be. Did you make any phone calls on her behalf to investigate whether or not the negligence case or allegation of neglect or whatever was dismissed?
I recall Ms. Lipscomb asking me to reach out to, was it Wolverine or some of these other facilities, CPS too? And I did do that. I did reach out to them. I didn't get through to anyone at CPS or at Wolverine, because again, this was right in the morning and then Miss Lipscomb was there. So I didn't call him multiple times, but I do recall reaching out to him.
So my next question is, are you aware that you are under oath? And are you also aware that our conversation was recorded and that I do have everything on flash drive as to our conversation on that date of the hearing? Are you aware of that?
I am aware of it, yes.
Okay, so you do say that you reached out to Wolverine and that you did reach out to CPS as I requested in your office on the date of the hearing. You're saying you did that, right? And you did say yes to me that you would do so.
Miss
I'm
Miss
sorry, that
Lipscomb,
you said no, that you wouldn't, that you was not going to. I'm sorry.
Sorry.
go ahead, Clay. As long
I
as it speeds
recall,
us
Ms.
up.
Lipscomb, you wanted me to call people. I recall trying to make a phone call. I don't think I talked to anyone or anything was very fruitful about those requests.
I'm sorry, fruitful? What?
I
I'm
don't
sorry.
think the requests, I don't think my phone calls got us anything or any information that I was seeking.
So pretty much on that date of the hearing, what I'm asking is, I asked if you could reach out to certain entities, agencies to support.
We already, listen, already asked that question, ma'am. That question has been asked and answered. Let's move on. You got another question?
Yes, sir, Your Honor.
And Mr. Miller, while she's formulating the next question, I have a basic question, fundamental. In the handling of this case, the effort to reach out to other entities or agencies, the success or non-success of any of those efforts, did it impact your ability to handle this case?
No, not at all.
Was there anything about your handling of this case that in any way was diminished or ineffective from the standpoint of what you sought to achieve at that hearing, based upon not being able to reach certain agencies?
No, I genuinely believe I did exactly what I was there to do the day I was there.
All right, other questions, ma'am? Any other questions?
Yes, my final question, Your Honor, thank you, is do you feel or did you feel differently about the case after you had a conversation about the case as a whole? You state you took the case because you believed that I was innocent. But once you had the conversation with, I believe it was the prosecutor and someone else, other persons that was in the courtroom, did you feel differently about the case? And that is why you approached me the way that you did, saying that I was toying with the system. Because that is what allowed me to say I didn't want to move forward. I didn't feel safe or comfortable with you.
No, Miss Lipscomb, I always believed in your innocence, believed that you were a good parent. The reason I may have come at that point is because I was learning things that I wasn't aware of when I talked to the prosecutor, right? And so you got to understand, I'm getting all this information from you. I'm showing up. I'm getting all this information from CPS, from Wolverine, from the prosecutor. Like, there's a lot going on. And so I never doubted your innocence at all. I just was being made aware of more and more details every moment.
All right. Thank you, ma'am. I believe that's enough inquiry on this. Mr. Hill, any redirection on this, sir?
There's just two very brief questions, and I promise I'm done. Mr. Miller, do you recognize what I pulled up on the screen?
Yeah, that's the bill or the invoice we sent Miss Lipscomb.
Okay, and it was sent on March 31st, 2023, correct?
Correct.
And it was due upon receipt. Is that accurate?
That is accurate.
Last question. If forced to hold the hearing for the show cause on April 3rd, were you prepared to handle that if your adjournment request was not granted?
I believe I was, yeah.
Nothing further, Judge.
And I would like to respond to those two questions, Your Honor.
You certainly can. You got questions on this in regard to this, ma'am?
Yes, Your Honor. So at the time that you sent me, Attorney Miller, the invoice, the conversation that you and I had was that I could pay it then, or I can pay on Monday, the date of the hearing. Is that true or false?
I would guess that's false. That's not how we operate. Generally we would like it before the hearing.
So that leads me to now ask you then, why did you not send me an email or call me to say you didn't get the funds before Monday, so we can't represent you?
Because I was always willing to represent you and work with you. We just needed the payment before court. I was under the impression you were going to pay over the weekend. When you reached out Monday and you hadn't paid, I was going to work with you to make payment so we could help you. That's why.
Were you not aware of the fact that I was comfortable paying on the date of the hearing and that was okay with you?
Judge, objection outside of my redirect.
It is outside of redirected. It's not relevant at this point. I mean, at some point, the parties had a mutuality of understanding and a payment was made, the payment was accepted.
Thank you, Judge.
Whether or not they had a fight or whether they had a happy ride to that conclusion, that's what happened. There was a bill for $2,500. No question about it, Ms. Lipscomb paid that $2,500. So we don't have to get into that part unless there's some other question and it's limited to Mr. Hill's inquiry on redirect. And I don't think that there's any other questions along this line regarding the bill. Unless you have a question about whether or not the bill was paid or whether they negotiated the payment or whatever. But it seems to me that the Detroit Legal Group acknowledges receiving $2,500 from Ms. Lipscomb, and Ms. Lipscomb acknowledges that she paid the $2,500. And it seems to me that the party acknowledged that that was done on Monday and that it was done before the hearing. And that
Thank you, Judge.
Further, that Mr. Miller acknowledges that he continued to work on the file in anticipation that Ms. Lipscomb would do what she said, and that is that she would pay and prepare to go to court that day. That's what happened in this case. And then there was a disagreement. All right. All right.
My final, I have another question, Your Honor, if I may.
Where we are in the case. Let me hear your question.
Okay, thank you, Your Honor. Attorney Miller, did you state in your office that you had not, I can't remember if the words, the choice of words were, you didn't have time to review because it was too much, or you didn't get the chance to review everything? Can you clarify that for me?
That's already been asked.
Yeah.
Yeah, that's already been asked and answered. Yeah, I mean, you asked that question, Mr. Hill asked his client that question, and I may have even asked that question. That's been answered several times. Yeah.
I just wanted on the record that there is an audio of what was said exactly to me on that day.
What did you say? I didn't hear you then. You said that you wanted on the record what?
Yes, I just wanted to state, Your Honor, as a reminder for Attorney Miller, that there is an audio that reflects the fact that pretty much he did nothing toward the case per his verbiage to me on the date of the hearing. And he really didn't have time to review it.
All right, well, that's not the testimony in this case. But if you have something that you want to use for whatever purpose that a lawyer said on a tape that I haven't done anything on this case and I'm coming to court with you and I've done nothing, I don't know nothing about this case, come to court. Then if you got that, I guess you could do something with that. That doesn't seem to be what happened in this case because you gave money. You had a couple of hours before the hearing to talk about the case. You had some time prior to bringing money to talk about the case, and you sent a multitude of documents. That doesn't seem to be something that would represent what this case is. But again, if that's what you have, ma'am, that's what you have. I just don't see that I don't see that as evidence in this case. All right. Now, having said that, The evidence is in this case, I think sufficiently. Parties have had ample time to provide to me whatever they wanted to. The documentation of this case is clearly before the court, and it has to do with what happens to $2,500. This is not a case where there is an allegation of further damage or harm to someone. Ms. Lipscomb hired another lawyer to do some work for her on this case. And she fired the lawyers that were representing her, and she's asking for a refund. And so that's what this case is about. So now we come to that part where Ms. Lipscomb, you get to be first with your closing statement in this matter. That is a summary of what you believe this case has shown and what you're asking the court to do. And then Mr. Hill will have an opportunity to argue to me what he believes this case has shown and what he's asking the court to do. And then Ms. Lipscomb, because it's your burden of proof, you get the last word. So you go first, then Mr. Hill presents his side by summary, and then we come back to you, and that's the final statement. All right? You may at this time, Ms. Lipscomb, you may talk.
Thank you, Your
I'm
Honor.
sorry. I'm sorry, Your Honor.
No. Cool. I don't want to.
Okay.
Forget it. Go ahead, Judge. Sorry, forget it.
Let me make this status for the record that it was indicated to me that Mr. Attorney Coleman Potts, who works in the Detroit Legal Group office, might have some testimony, or there might be some testimony offered. I believe that if there is some more to be offered here, it probably is voluminous and not particularly relevant.
Duplicative. Yes, we're good, Judge.
You're resting, I believe, Mr. Hill. Is that correct?
Yes.
Sir?
Yeah, I'm sorry, Judge. Yes, we're done.
I believe that everybody's told me what they want to tell me. There are disagreements for sure. And that's why there's a case in front of me, because the parties disagree. Ms. Lipscomb, you may proceed with your argument at this time.
Thank you, Your Honor. Your Honor, this is a case where I hired Attorney Clayton Miller to represent me on a very emotional, very stressful, very concerning case in the behalf of my severe mental ill daughter. I made sure that Attorney Clayton Miller not only had all of the evidence to support my innocence, but to support the fact that my daughter needed to be transported to a different facility that would be able to treat my daughter appropriately and to get her out of an abusive situation, yet being scared for my daughter's life, my family's life, looking to him, entrusting him that he would get resolution in a positive manner in my behalf. When I initially contacted the firm, I made sure that I asked if their firm specialized in juvenile cases, and was told yes. From the action and the demeanor, from what I was told, I believed and entrusted. However, upon going to the courtroom, I saw totally different. And it was based on what was said to me after the adjournment was requested, what was requested by Attorney Clayton Miller. And the negativity that I received, I didn't feel that I was in good hands. And that the evidence that I had to support my innocence, it was not brought forth as far as, saying my client is here, my client is not running, but I do want to request an adjournment because it's a significant amount of it, and none of that was even brought toward me, so I was left in limbo. But then I also gave him the opportunity to prove himself as he wanted me to allow him to, and then I was failed again. This was my life, my credibility, my excellent team. I felt like it was almost like I felt crushed on everything. So I then in turn, after giving Attorney Clayton Miller a second chance. I did in turn, and he felt me. I felt there was a need to hire another attorney, another $1,500 that I had to pay out of pocket. Although I got resolution, there was a positive outcome in my behalf, yet I felt as if I was scammed. I really felt like I was scammed upon. Yeah, I just felt as if he knew all along he was not going to represent me. As if, I'm a female, I didn't come in with no man, I came in by myself. I was honest with him about everything. I laid everything, all my cards on the table. I told him more than enough information to go into the courtroom, and represent me properly. And I just felt like he didn't do that, whether it would have been, we need an adjournment because, Ms. Lipscomb, we have evidence to support X, Y, Z. It was nothing. He pretty much, the courtroom said everything and he just stood there. It was, shall I say, the persons in the courtroom, were speaking, and I would say to him, well, can you say this? Can you let them know I didn't know, but I'm here today? It was nothing, it was nothing. And I just felt like he didn't have my best interest at heart. And so having to hire another attorney that got the job done and that spoke well in my behalf and was ready to present all the evidence, I just felt like and when he made the comment, he didn't know what to do. That also was my concern, not just the negative verbiage that he stated to me of me toying with the state. Just him saying to me he didn't know what to do, that really, really struck my concern. And then after I even gave him the opportunity to make it right, he didn't show up. So I just feel, Your Honor, at this point, having everything he needed to support me, whether it be requesting an adjournment or on the show cause, and he didn't do what I feel was appropriate in my behalf, I do feel that not $1,000 is reasonable. I feel that that's very much so unfair to me. I feel that $2,000 is well worth a refund to me, especially being that I had to come out of pocket and pay $1,500 to another attorney. And I provided all evidence to support that Attorney Clayton Miller had everything he needed. However, he chose to approach the honorable courts, he had more than enough information to speak in my behalf, whether this representing me on the show calls or, even asking for an adjournment. He had everything. He said nothing really in the courtroom, nothing. He literally just sat there like nothing. And that is supported. I've supported everything that I've stated today by way of audio. From everything that happened in court to the conversation we had outside the courtroom to the conversation we had in his office. I supported everything. I've supported emails. I've supported text messages. I've supported everything. And I do want to say, no, I never supported a call log. So I do want to clarify that. I never provided a call log. I don't think I provided that. I didn't. No, I didn't. But I have more than enough information to support that Attorney Clayton Miller did not spend also the amount of hours as he stated that he did on the case. He did not. And my audio to the honorable courts as well as to the defendant supports that. I want to say there was maybe about a good, maybe 2 hours and 20 minutes or 2 hours and 15, I'm sorry, let me take that back. 2 hours in his office, 15 or 20 minutes by phone. And I want to say the court hearing went maybe about an hour or an hour and a half. So altogether, I want to say probably about 1, 2, 3 3 hours and four, I'm sorry, 1 to 3.5 plus the 15 to 20. So not even 4 hours altogether. And that is supported through all of my evidence that I provided to the honorable courts as well as to the law firm. And so
Oh,
it's
sorry.
not, as well
Right.
as.
I thought you were done, Ms. Lipscomb. Sorry.
Oh, it's
ahead.
okay. It's okay. And then also I am seeking, Your Honor, all of my fees that I paid toward motions. I haven't had the opportunity to add them up because I'm so busy with working jobs that I just haven't had the opportunity to do that. But I've paid a significant amount of monies out of pocket toward the motions. And I've also paid, I want to say, for the sheriff's service to serve twice, I believe, upon the defendant. I believe both of those were 28 or 27.50 plus 27.50, and each motion was like $20 each. I did initially request that you fund me the $1,500 for the attorney that I had to come out of pocket to pay, but I just, I did initially request that because I felt like it wasn't my fault that I had to hire another attorney. And that is my closing argument.
Thank you, Judge.
Thank you very much, Mr. Hill.
Judge, just as it relates to the cost she's asking for, I'd like the court to be cognizant of the fact that I'm pretty sure that she didn't show up to a hearing and it was reinstated. I think she's asking for those costs, just so the court's aware. I could be wrong. I'm asking for a no cause, Judge. I'm not asking for any costs affiliated with this. This has consumed my firm, I want to say 4 or 5 separate hearings after it was dismissed and reissued. I have 3 attorneys here. We could be doing other things. I will say this, Your Honor. I started this law firm, Detroit Legal Group, with the Honorable Jeffrey Kleperick in 2009. I have never once been sued on a legal fee. Never once. Why? There's always going to be disputes. I think what I've done is fair. I always try to negotiate and I try to figure out what's going on. In this situation, first of all, when I found out Mr. Miller did all this work without being retained, I was furious with him. We have a policy, and I told him, you shouldn't have looked at those emails. You shouldn't have communicated with the client. You should have told her, you know what, we can't help you. Unless you pay, you can't help. We can't help you. But he's a younger attorney. He's trying to make good for the law firm, and I appreciate that, Clay. I do. At the end of the day, Judge, again, I've never been sued on a legal fee. I called Ms. Lipscomb myself. She acknowledged that I called. I made an offer. I thought it was reasonable. If you take into consideration the hours that Mr. Miller testified here today about, Judge, it far exceeds what we submitted. And the only reason why we submitted that Clio invoice was to show the basic hours that we put into this case. I was willing to give Ms. Lipscomb some money previously because I wanted to make her feel satisfied. I'm hoping the court can see, regardless of what we did, I don't think Ms. Lipscomb was ever going to be satisfied with our representation. She disagreed with she pretty much countered everything that Clay said. Focusing on the facts, we have a Friday before a Monday hearing. Mr. Miller spends a couple hours talking, receiving 40, 50 emails, spends his weekend at his house going over this stuff, and lets Ms. Lipscomb know that she has to pay. She pays. He has an hour and a half to prepare for a hearing. He's testified he would have been ready, willing, and able to hold the hearing if required. He still goes to the hearing, spends 2 or 3 hours at the hearing. Just the math alone, Judge, those hours far exceed what we put in the Clio invoice. I'm asking for no cause. I don't want any money from Ms. Lipscomb because I think she feels that she was wronged. She wasn't wrong, Judge. She wasn't. And I appreciate Mr. Miller's, him being candid and honest and saying, listen, Ms. Lipscomb, give me a chance to fix this, right? There's nothing to fix, but in Mr. Miller's mind, he's thinking that he has an angry client. He's a newer attorney. And that's when I had a conversation with Ms. Lipscomb. And I realized that there was no way that we were going to make her happy. And I didn't have to, Judge, but obviously there's an invoice that we provided. She's acknowledged receiving it. It clearly says $2,500. I'm asking the court for no cause, and I'm asking for no fees, no anything. I don't want anything to reinstate the case because I think originally it was dismissed. I just want a no cause, Judge. And I want to move past this and be done, please.
Thank you, Mr. Hill. And Ms. Lipscomb, you get the last word on this matter.
Okay, Your Honor. Thank you so much. I just want to say to Attorney Hill, your experience and you never being sued on any type of other cases has nothing to do with how I was ineffectively assisted by your counsel, by Attorney Clayton Miller. That has nothing to do with the poor assistance that I received. That's the first thing that I would like to say. I don't recall you calling me in regards to the situation. I actually called the firm. And I mentioned that after allowing Attorney Clayton Miller the opportunity to make it right in my behalf, having all the evidence to support everything that he needed, because I'm very thorough, he stated for me to allow him the opportunity, and I did, and yet he failed again. I'm never angry. I want to take it for the record. That sounds like a mad woman. I'm never angry. I'm actually a humble individual, and I'm the sweetest person ever, and I'm very honest too. So to say that I was angry, I was never angry with Attorney Clayton Miller. If you'll listen to the flash drive that I provided you of the recording, I actually was begging him, pleading with him. And it's a flash drive with the recording on that date when he stated to me, I'm toying with the state of Michigan. He was mind manipulative. And that was very hurtful on my innocence. Not only do the honorable court have the flash drive, but you guys have the flash drive of the recording. So everything that I'm stating here today in court is the truth and nothing but the truth. So help me God. But what do you all have? You don't have a recording of me being angry. You don't have a recording of me falsifying any information of the case. You don't have anything negative. I have everything to support everything that I've stated today that's been provided and was served upon you as well as served upon the honorable court. They can see my evidence that Attorney Clayton Miller failed to represent me appropriately, no matter what it was, whether it be a show cause, an adjournment. I was wronged, very much so. And I'm sorry, I do feel that $2,000 is fair that I receive back from your firm, as well as all the fees that I paid toward the motions and the service fees. And that'll be all, Your Honor.
All right, thank you. Thank you, Ms. Lipcomb. Thank you, Mr. Hill. And of course, the evidence and the arguments are complete in this matter. And I've gone over items that were submitted to the court, just in the sense of having a sense of what this case is about. And this court has the responsibility to address the court from the standpoint of the central issue that is involved in the case. And of course, a part of judging the central issue involved in the case is to weigh the credibility of witnesses, recognizing that sometimes witnesses say things that may not be altogether accurate, but it does not necessarily constitute that they are telling a lie. It may be that they're mistaken or that they saw the facts differently. There is certainly some issues in the case at bar that where the parties saw things differently and from a different perspective, and there are good reasons for that. I believe that I heard Ms. Lipscomb talk about the fact that she is a nurse and I believe involved in some type of physical therapy kind of issues, but she has a professional career track that she has been engaged in for many, many years, and obviously very successfully and does her job with great proficiency. And one of the things that I would not like to do is to second guess her on how she does her job and the decisions that she makes along the way in the manner that she does her job, because she's professionally trained and she has a certain amount of discretion to do it a certain way because of the training that she has. Another nurse may do the job a bit differently, and how they do it may be based upon their training, their experience. What is required in all professions is that you meet the standard of care and that the function that you carry on, that in carrying out that function, that you do it in a manner that is diligent and that meets the duty of care, meets the duty of responsibility. Indeed, of course, I have a sister who is a medical doctor, and one of the things that we go back and forth about is that we play role reversal at times. You know, she tried to play lawyer, and I tried to play doctor. I tell her that most people would rather for me to play lawyer than for her to play doctor. My point being that she comes from a different profession than I do, and for her to judge the way that I do what I do probably is going to fall flat on its face. Likewise, for me to judge the way that she does, unless I acquire a whole other set of skills, would probably fall miserably flat, because she's good at what she does. I hope that I'm good at what I do. In this case, the situation comes down to the fact that there was an agreement for the representation of Ms. Lipscomb with regard to a show cause hearing that was pending in family court / juvenile court, involving a daughter, one of her daughters, who has a mental illness, and secondary to that mental illness has suffered institutionalization. And as a result of the institutionalization, and Ms. Lipscomb being an on assignment parent, she received and was given notification that she had to pick the child up from a treatment facility. And apparently she differed with that because she did not pick the child up, believing that it was unsafe to do so for the child and for her family, and that other decisions had to be made. As a result of that workup, as Ms. Lipscomb had provided to the court, as a result of that workup, she felt that she needed legal counsel to assist her in what laid ahead of her, and that is that she had to go to court on Monday following the 31st of March of 2023. She obtained representation of counsel. It seems that the record is replete with that retention occurring on the 31st of March, although there's been some testimony regarding the 30th of March. In any event, on the 31st of March, a receipt or a note was generated indicating that a fee of $2,500 was charged. It was not in the nature of a fee agreement. It was in the nature of a set fee that was set out for $2,500 for a particular service that would be provided by this office. There was a discussion that was had on the 31st with Mr. Miller, and upon that discussion, Mr. Miller advised that there would be a fee of $2,500, and also provided information, gathered information regarding what the case was about, and instructed that information was to be sent to him so that he could begin preparing for the case. It is undisputed in the testimony that Ms. Lipscomb desired that Mr. Miller prepare for the case during the Friday and the period preceding that Monday when the hearing occurred, and that Mr. Miller indicated that he would get involved and began to prepare for the hearing. Even though a fee had not been paid, that the agreement between the parties is that Mr. Miller would receive information from Ms. Lipscomb, and that he would review that information in preparation for the hearing. The clock begins on the 31st. The 31st is when Ms. Lipscomb has the right to send information to an email address that has been provided. She also has been provided with a text a number where she could send text messages, and she began having communications. All of those are generating what is commonly referred to as billable hours. In addition to that, when Monday arrived, Ms. Lipscomb, based upon her promise to do so, she came to the office, and upon coming to the office, she brought with her the $2,500 fee for the services that had already begun on the 31st. Bringing the $2,500, she also had discussions and preparations with Mr. Miller during that time leading up to the hearing that was to take place later in the day. Those discussions were in the nature of an hour and a half to 2 hours, and could have been as much as 2.5 hours, but nobody seemed to be taking very careful notes about how much time was involved, either on the 31st or on the day of the hearing. And it would seem to me, based upon some of the testimony that was offered here, that the thinking of the Detroit legal group was that this was a flat rate. And the reason that that seems to be borne out here is because there was no set documentation of how much time was spent on the 31st. There was no set documentation of how much time was being tallied on the date of the hearing, how much time was spent at the hearing. Only in retrospect does the parties began to look at those kind of items, because that makes sense. The understanding, at least for the firm, was that whatever she needed us to do, we're going to handle it for $2,500. If it's 5 hearings, if it's 6 hearings, if it's 2 hearings, we're going to do it for $2,500. Two things before I go further. Number one, the firm, I'll slap them on the wrist for not getting a fee agreement hammered out right away, so that you could drill down on the issue of it being a flat rate, which in many ways it errs to the benefit of Ms. Lipscomb that they didn't do it that way. Because had they did it that way, probability is that the agreement could have been an hourly rate agreement. And if it was an hourly rate agreement, then that makes things different than a flat rate agreement, et cetera, et cetera. So in other words, it's the firm should have put an agreement out there to lock down the issue of whether or not this is a flat rate or whether or not this is an hourly rate, or so on and so forth. I have to conclude that it's a flat rate because I don't have any evidence to the contrary, because I know there's an agreement, because money was paid, money was received, and nobody is disputing that that money was paid and received for legal services. And if I concluded that this was a fee that was paid based upon some kind of hourly rate, then that would mean that the $2,500 could be expended in it just measuring hours that might have been involved, and not based upon some type of flat rate wherein the court could think about it and say, well, they charge a flat rate, but here's what I think should happen with this flat rate. In other words, if I look at this, and Mr. Miller under oath has testified that he used a reasonable amount of diligence on Friday to receive emails late in the day, and that he went over emails that he showed the court by way of evidentiary presentation, the various emails that were sent to him that were voluminous. That one email that had many different attachments to it, and in the nature of somewhere between 30 and 50 emails with multiple attachments to each email. I can tell you right now that if a lawyer is charging a reasonable rate as a lawyer in the nature of $200 to $250 an hour, if you send that lawyer 30 to 50 emails with multiple parts to it, you're going to spend $2,500 that day over that weekend. Even if they don't read all of it, that's going to cost you $2,500, because 10 hours worth of material is $2,500. And it doesn't mean that a lawyer has to use 10 hours to review the materials. If a lawyer uses his expertise and he can do it faster, but it's $2,500 worth of work, he can charge $2,500 for that. That's why Ms. Lipscomb could go to one lawyer and that lawyer charge $1,500. Another lawyer could charge $2,500, and then you could go to I'll just throw a name out there, Jeffrey Feiger. Maybe he charges $25,000 to go to that same hearing, because lawyers can charge differently based upon the years and years of experience, based upon them showing up in court, and maybe they get a whole bunch of attention because they show up in court. So that hearing becomes a $25,000 hearing for them versus a $2,500 hearing if it's somebody else involved. All of those nuances are part of the way that this works. So this is a flat agreement. This is an agreement that says, to Mrs. Lipscomb's benefit, although this changes along the way because the parties disagree. This agreement says that I'll do 2 hearings for you if it's necessary. I'll do 3. If we gotta go to court 4 times, so I'll go to court 4 times. I can tell you that most lawyers charge a minimum fee of $500 to $1,000 for each court hearing. And that's, that's kind of basically, it's gonna be very hard to not talk about a $500 fee just to go to court. We haven't talked about preparation for court. We haven't talked about counseling after court, and things along those lines. So the $2,500 agreement, I mean, it's money out of Ms. Lipscomb's pocket, it's money into the law firm. This is a little bit of money, and I'm not trying to undermine and diminish it. It's a little bit of money. And I feel a little bit of frustration in 2 ways. One, I have a professional lady here that is trained in her profession, and she does what she does to advance her journey. A very respectable lady, very intelligent lady. And then I have 3 lawyers that have navigated law school, passed bar exams, and that operate a law firm operation, and that quite frankly are frequently in and out of this court on various kinds of matters, and so on and so forth. So today, you have a judge that bills out, and I don't really bill, but when you calculate the way I get paid, that bills out, I think, somewhere about $450 an hour. You have lawyers that a partner that probably bills out at least $500 an hour, and then you have one associate that bills out at about $300 an hour, and another one that bills out about $225 an hour. We spent $25,000 in time on this case already. And I'm not just talking about the lawyer's time and my time. I'm talking about Ms. Lipscomb's time. Everybody is spending a whole bunch of money on this. When really what this case is all about is a disagreement about the manner in which Mr. Miller went about handling this case. And I'm so glad that I took the time to hear this case. I tried to get the parties to settle this case because I realized that Ms. Lipscomb has a life, Mr. Miller has work, Mr. Potts has work, Mr. Hill has work. And I tried to get the parties settled. It might have been somewhere $200 more than what Mr. Hill said. It really is not that big of a deal, because what lawyers like to try to do is to find a way to resolve it, because you want to do the best you can to make a client happy. You can't give away the store, but you want to do the best you can to make a client happy. And sometimes it just doesn't work out. So what is this case about then? I won't talk long on this. Here's what I have to find in this case. What I have to find in this case is that Mr. Miller responded to Ms. Lipscomb's request to review documents and to accept retention on a case that involved a show cause hearing. That the fee that was charged as a flat fee, that I have to find as a flat fee for a show cause hearing, there is no way on planet Earth that a $2,500 fee for a show cause hearing is an excessive fee or an overrated fee. It's impossible for that, because a show cause hearing is a hearing where the fundamental rights of the litigant can be affected by the outcome. That is, that if a person is found guilty on the show cause, that could mean that person goes to jail. That could mean that person has a conviction, so on and so forth. And so the responsibility of Mr. Miller was to navigate carefully and to make sure that he had the broadest range of options made available to him before going in front of the judge and putting all of the evidence that he may have had in front of the judge. It was not unreasonable then for Mr. Miller to conclude that going to the hearing when he has been retained as of Friday and it's now Monday, he would have been foolhardy to go into the hearing on that Monday and say, I'm ready to conduct a full show cause hearing on Monday morning or Monday afternoon. That's not a wise lawyer approach to a case, especially when he's received 30 to 50 emails with voluminous attachments to those emails. And he has a client that has come into the office and has spent an hour, hour and a half, maybe 2 hours of discussion about this case. And this case involves a minor to which Ms. Lipscomb has some responsibilities to deal with that minor. I know that it's been suggested, I don't know how long Mr. Miller has been practicing law. I'll tell you the problems and concerns that I have. I don't know how long he's been practicing law, but I know one thing. The first rule of practicing law, when it involves some significant and fundamental rights that may affect your client, is be careful. That's the first rule, is be careful. That you cross every T and dot every I, so navigate carefully going forward. So he gets a bunch of information, he gets to court, and he finally gets to court to meet the other interested parties. The interested parties have to do with the facilities where she's staying, the prosecutor in the case, whatever persons are involved in the treatment plan, the judge in the case, and in this interaction and exchange with them, now he has information from their perspective, as well as information from Ms. Lipscomb's perspective. And the testimony here is that the position that Mr. Miller went into the court with is the position that he ultimately decided that he should come out with, and that was to get an adjournment of the matter, to live to fight another day on this. And here is where Ms. Lipscomb has a concern. Ms. Lipscomb is resolved on that day. Ms. Lipscomb wants Mr. Miller to go in front of the court and tell the court how good of a person she is and why all of this stuff is just made up and it should be, she shouldn't have to be here to fight this matter. Many clients want their lawyer to handle the case that way. And if you're locked up behind bars and a lawyer is trying to get you out of jail, that may be the only approach that the lawyer can take. Maybe the only thing they can take is to throw all their goods out there to try to get you out of jail. This is a situation where Mr. Miller has his client who's not in jail, who no action has been taken against, who nobody is telling her that she now has to be locked up for a rule that she violated. There was an order issued that says she's got to pick up that child. She did not pick up the child. She is technically in violation, and a show cause has issued that could result in her arrest and her being taken in for incarceration. Mr. Miller goes in, he talks to the relevant parties, he comes back, he talks to Ms. Lipscomb, I find, he tells Ms. Lipscomb some of the things that he's alarmed by. There is a breakdown in communication because he's alarmed by the fact that what they're telling him is that she needs to get this child because this child, this facility is being closed down. She didn't come get the child. Now, a show cause has been issued against her. She can go to jail for that. And he's alarmed by that. He tells her that, you can't play with these folks. You gotta deal with these folks. I know you're a good person, but you got to deal with these people because they can end up locking up a good person because something didn't go right here. That's the conversation. Ms. Lipscomb doesn't like that conversation. She wants her lawyer to get up there in front of the judge and to put on a show for her that she believes would be a better representation. To go in front of the judge and say, this is a great person. Why are you all messing with her like this? You should not be treating her this way, and so on and so forth. He could have did that. He's not required. What he's required to do is to make sure, to the best of his ability, that the fundamental rights of Ms. Lipscomb is not adversely affected without putting up a great fight. He put up the fight that was necessary to make sure that her fundamental rights were not adversely impacted. He did not have to persuade the court of how good a person she was in order for her to get an adjournment. He came out of there with what he needed to come out of there with. And having come out with an adjournment, and all of the paperwork and documents that have been sent to him over the last 72 hours, he now has additional time to drill down on whatever issues need to be dealt with to be fully and thoroughly prepared for everything that all of those parties that were there, all of the interested parties in this child's life, that they were there ready to come at Ms. Lipscomb for. And for him to go in there on that first day and to go on attack probably would not have been the wisest approach. Maybe he could have did that. But as a lawyer, he has the right to make a decision about whether or not this is the best day to fight, or whether or not we need to come back and fight on another day. the other issue that comes up is that, well, there was something about, Mr. Miller, well, the long and short of it is that I wanted to point out here is how that, Mr. Miller, he didn't raise the kinds of things that, his client wanted him to raise because they weren't necessary. Some of the lesson to lawyers that may be just coming along is that every now and then you got to raise some of the issues that your client wants you to raise, as long as it's not going to hurt them, even if you know it's not going to help. Every now and then, for example, you got a situation where a person is in jail for something pretty serious and they're on a $500,000 bond. Sometimes you got to stand up there and say they're a good person and judge, you should let them out of jail and so on and so forth. When the reality of it is that that bond is not going to get reduced because they did something really crazy. Sometimes you still got to, with a straight face, say this is a really good person and that bond is really too high. Well, in this case, Mr. Miller didn't have to, he didn't have to say, he could have got up there and said, this is really a hardship for her. She's a really good lady. They shouldn't have her here. She shouldn't be going through this. And probably this is a bit of a mistake and what have you. And what was going to happen if he said all of that? And Mr. Miller said all of that. If he said that this lady has documents that she's a good mother. This lady has documents that she's always been there for her child. What was going to happen? And I know Judge Miller, she served on this court. She was my colleague for many years. What was going to happen in front of Judge Miller? Judge Miller was going to grant an adjournment. If Mr. Miller went in, and I know that they're not related, but if Mr. Miller went in and argued the entire case, saying that Ms. Lipscomb is a wonderful lady, she's a professional, she takes care of her child, she has other children at home, she's very responsible, Judge Miller was going to grant an adjournment. By the time the other lawyer got there, there was more nuance to the case that I'm sure resulted in that show cause being dismissed. And I would suggest, although I have no evidence here, that the position that the case was put in by Mr. Miller bringing it before the court and setting up an adjournment, bringing Ms. Lipscomb in, showing that she's not running from anybody, is the reason why when the next lawyer comes in, that the case gets shut down. That this whole thing about the show cause gets wiped out. Now, the thing that I was trying to think about was the testimony that said that what Mr. Miller said. Yeah, I may have said I don't know what to do here. I don't know what I'm going to do on that. That fits with what Ms. Lipscomb was saying. Ms. Lipscomb was saying that the facility was closing down. They're closing this thing down. They ultimately close it down. Mr. Miller goes back. He has discussion with the various parties, and they're saying this young lady's got to be picked up because they're closing the facility down. It's not going to exist anymore. He comes to his client. He said, I don't know what are we going to do? You don't want to pick the child up because you feel it's a danger. They haven't moved the child to another location, and this facility is closing down. Yeah, there are nuances in the case. What the case really comes down to is a disagreement based upon communication. Ms. Lipscomb had a decision in her mind as to how the thing should go in court. Mr. Miller used his best legal skills to figure out a way to get this case in position to argue on another day so that this show cause and all of this get knocked out and this child get placed into the proper facility or be able to be brought home without there being an adverse impact on Ms. Lipscomb. And that's the critical thing here. It's because and I didn't know that about this case until today. I heard the testimony that this case was about a show cause hearing. A show cause hearing is not, come, let's have a discussion about how and when you're going to pick up your child. That ain't this. A show cause is an order saying that you have violated a court order, you are in contempt, and the court can send you to jail for this. And it was wise for Ms. Lipscomb to go and get somebody that will help her with the case because she don't want to walk in there on her own and not have someone that can be a spokesperson. Mr. Miller covered what he should cover, and that was to make sure that no harm came to her and that she lived to fight another day. And what about this living to fight another day? Living to fight another day was already paid for. Ms. Lipscomb was not gonna have to pay another dime. The fighting another day was already paid for. The firm had already agreed that we're on the hook for, you paid the $2,500. We gotta get you through this. We got you an adjournment today. We gotta get you through this. We have got to get you to the finish line. Ms. Lipscomb made the decision that she did not want the firm to get her to the finish line. She made that decision. Now, in the process of making that decision, what is it that occurred? Listen, I listened to the testimony, and Ms. Miller says that when she called and talked to Ms. Lipscomb says when she called and talked to Mr. Miller, the initial call, the discussion about $2,500 fee, she told me in her testimony that when she first called there, she told them all about what was going on. She told me that she discussed everything. She was telling them, and then afterwards, she sent the information. Now, she thought it was on Thursday, the 30th, but she said she had an extensive conversation with Mr. Miller. She told him about everything that's going on. Well, then she testified that discussion took 15 minutes. Listen, I believe that Ms. Lipscomb is an honest person, but I can't imagine a scenario in which Ms. Lipscomb would call to talk to a lawyer about this case that she is emotional about and has a lot of issues. I never said angry, but that she is emotional about. She has strong feelings. I get it. I have 6 children. But anyway, but she said that conversation was 15 minutes. She can't handle 15 minutes on the Zoom. There's no way. I mean, and that's not to put her down. I respect her highly. Listen, I've taken a lot of time with this today because I believe it's important. This is important. But 15 minutes, Miss Lipscomb, it takes her more than 15 minutes to clear her throat. And I'm being a little bit facetious here. There's no way that you called and talked to Mr. Miller and told him all about this case and discussed the $25 fee agreement in 15 minutes. No, just come on. That doesn't fit with any sense of the personalities that I see involved here. It could not happen. It's not 15 minutes. No. Tell me 45. Tell me anything but 15 minutes. No. That's if there's any, I don't want to call it a lie, but if there's a red herring in the case, something that just stick out like a sore thumb, that's it right there. That's 15 minutes. Come on now.
I said 15 or 20 minutes, Your Honor.
My time to talk now. My time to talk now. My time. Now, you can't say anything now. But I just want to raise that. That's not something that's going to cause you a great deal of harm. I just want everybody to see this case. I mean, I sit here and I listen to everybody involved. 15 minutes. Come on, let's say not a chance in this 15 minutes. And you send a bunch of emails, and the attorney, whether he reads all of them or just looks at them and glances them, trying to figure out what's going on here and there. That's a lot of time to do that. You got. Let's say it's an hour and a half, hour and 15 minutes, whatever this discussion is, because Mr. Miller's trying to get up to speed on what's going on. He gets all of these emails. That's time being spent. Come into the office. There's another hour and a half of preparation leading up to the hearing, and then there's the hearing where he's going to talk to several parties that are involved in this thing at the hearing. On the hearing is a couple of hours. I mean, when you start talking about this, I mean, if you start out, let's say it's an hour. Then you send emails. Let's say that he didn't read everything. And there's no way that number of emails is going to be sent to him, and he's not going to have to put in at least a couple of hours. So if I'm being kind about it, I say, okay, here is an hour. Then there's another couple of hours of receiving emails. That's 3 hours. Then you come to the office. That's another hour and a half. That's 4.5 hours if I'm being real conservative. That's 4.5 hours. Then you go to court. There's another 2.5 hours involving court. So now we're at 7 hours. And then there are discussions afterwards, exchange, some of it's falling out. But you got somewhere between, easily, you can count 7, 8, 9 hours in this case, very, very easily. And I know that one of the things that any professional does not want to hear, if I was to tell Ms. Lipscomb that you can spend enough time going there to see that patient, that you went in there and you came out of there in 15 minutes, or you did this and you didn't do your due diligence on that. What she's gonna say is that, I know what I'm doing. Look at the result that I got. The patient got their meds, the patient's blood pressure was checked, the patient's other vitals were checked. The pillow was fluffed up. I made sure they had the little proverbial ice in the cup or whatever it is. She covered it. Guess what? Maybe another nurse, it'll take that nurse to go in there for 45 minutes to do that. But because Ms. Lipscomb been doing it a while, she was able to do it in 15 minutes because she knew exactly what to say, exactly what to do, because she had specialized training to do that. That's what lawyers do. That's what lawyers do. And the fact that they don't argue everything that you presented to them, and the fact that they tell you, honestly, you'd rather have a lawyer to be honest with you and tell you, you know what, you sent me a lot of stuff. I went through it, didn't get through all of it, because we had 72 hours in which we had to come. The fact that a lawyer would be honest with you and tell you that, I wish that in the 32 years that I've been on the bench, that every lawyer that came in front of me was as forthcoming. I wish that, because usually, if you're honest about the situation, people will disagree with you, but the honesty is enough all by itself. It's just being honest about it. If this gentleman had told you that he read every last one, I looked at the stuff as it was being opened, and I looked at the stuff that was sent to me. If this gentleman told you that he read, digest, worked on every last one of those emails, and knew exactly everything that all of those emails said by the time that he went to court 72 hours later, I would tell you that that's probably not true. That's probably not true, because it doesn't happen like that. When a lawyer, when they got to come to a hearing that soon, if it's a trial or something that they've been preparing for, that's different. When they got to come to a hearing that soon, they're trying to get the gist of it, so they can position themselves so that when they go in front of the court, no harm comes to their client, while they have additional time to finish out whatever needs to be done on the case. It sounds like that's what was going on here. Parties will forever disagree, but here is what I cannot in my wildest possible imagination conclude, that the plaintiff is entitled to a return of $2,500. And just like I can't conclude that, I cannot possibly conclude that the firm that worked on this matter, that all of what was involved in trying to prepare for this is about $500. How could that be the case? Now, you know, if they had set an hourly rate, then the $2,500 would probably be totally exhausted. Probably be totally exhausted, except with a flat rate, which complicates how this court deals with it, because they set a flat rate. And not only they set a flat rate, but they set out to do exactly what the firm promised to do. They adjourned the case, which means I got more work to do. $2,500 is here. I got more work to do. I've done work up to this point, and I'm gonna do all the rest of the work. They were willing and able and skillful enough to do all the work. However, Ms. Lipscomb has the right. She has the right to say, whether you are able or I think that you're not, I don't like the way you did it, so on and so forth, so I'm gonna fire you. But what she does not have the right to do is to get all her money back when they've done the work. You don't have the right to do that. Imagine that in your own profession. That someone says, I don't like the way you did it, I don't like your personality, so you did some work and you did work on the file, but you did work on the patient or whatever, but we ain't paying you. We ain't paying you because there's something about you that we don't like. We don't get a good feeling about you. We don't get a good feeling about what you do or what you did do, so we're not gonna pay you. Yes, they are gonna pay you. If somebody comes to you and goes to your supervisor and the patient says, I don't like that nurse, so and so, you're still gonna get paid. Why? Because you did your job. Did you do it the way they like for you to do it? The patient? No. But you did your job and you did not cause that patient any harm. So you're gonna get paid for it. In this case, I'm constrained to kind of like split the difference. But the fact of the matter is that as I looked at this carefully, it's almost like it's almost like a wash. But I know that the responsible thing to do, because Ms. Lipscomb said it early enough, and she didn't want to go any further, they give her some of her money back. Man, you almost got Ms. Miller almost got Ms. Lipscomb almost got a situation here where it's almost like you gave the money away and then you decided that I paid a flat fee, but I decided that I'm gonna quit. They didn't quit, you quit. That almost could be a situation where a court could reach the conclusion and say, well, you quit. You walked away. You gave a $2,500 and then you walked away from it after they did the initial part that they were supposed to do. They got the adjournment and they're willing to do the rest of the work. But with all this said and done, I'll give you $1,000 back. Yeah, it's that kind of call. In some ways, I wish the parties could could have sat down and worked this all out and whatever. But it's a tough cut. Now, I'll return $1,000. I'm not granting any filing fees, motion fees, or anything else. $2,500 is an unnecessary proceeding in many ways. The parties don't have to like each other. They had a contract, they had a contractual agreement, and Ms. Lipscomb decided that she didn't want to go with a contractual agreement. And why I do not take that into consideration, that there was some type of attempt to settle, because attempt to settlement, that don't really mean a whole lot to me, because that's what the parties do before they come here. But just after listening to everything, yeah, you know, I'll order the return of $1,000, and no filing fees or motion fees or anything like that are granted. No service fees are returned. It's $1,000. It resolves the case. The award of costs is denied, and judgment is entered, allowing the $1,000 to return to Ms. Lipscomb. That is
Judge, I'd like to renew my motion for costs for setting aside. The court rule specifically says when Ms. Lipscomb failed to appear and the case was dismissed, the court rule says that the plaintiff shall, or the defaulting party shall, pay actual costs and attorney fees. We have $1,000 in out-of-pocket expenses and attorney fees in responding to that motion. I'd also ask the court, actually, you know what? I'd like the court to make a ruling on that, please.
I never failed to show the court. I've been to every court hearing. The only one that I did not show to was the one on January 29th, and that was because, and I called the courtroom.
The case was dismissed. The court rule specifically says that the court rule specifically says that the court shall order the defaulting party to pay actual costs and fees.
I'm not in the court. I didn't show the court on January the 29th because I was told by the court clerk that the judge had an emergency, and that is what that hearing was adjourned to today.
All right. It seems to me that something that I recall about this may have been some confusion about the requirements that the plaintiff was needed to have. I don't remember all of the nuances of granting the order. But my inclination is that some of that responsibility may have been borne by the issues of court date and lack of notice to Ms. Lipscomb. For that reason, at this time, I'm going to deny the motion for assessment of fees in that regard. Now, if someone formulates a motion that provides other clarity regarding what occurred, and if it seems that it violates the court rule in some kind of way, then of course the court will rule consistent with consistent with whatever the court rules are. My indication here is that this case bounced around a little bit, and that
she missed a court date. She missed a court date.
I did not.
It's unequivocal. She missed a court date.
No, I did not.
Ms. Lipscomb, I'm talking right now.
Not one court date, because
This is
you're
absolutely ridiculous. I'm sorry, Judge. Listen, we've been to court 6 times on this. It has cost my firm thousands of dollars, and she's lied the entire time.
That's not true.
Woman.
First of all, the court date that was on January the 29th was adjourned.
So
Your Honor, I'll follow the motion for reconsideration, with regards to the motion for our costs. I'll follow the motion for reconsideration, get it to you.
You
Your
can do
Honor,
that.
I have
Stop
not-
now. Stop. You interrupted someone else while they was arguing. Now, I want you to do something, Mr. Paz. If that's what your firm wants to do, I'll hear whatever motion. I think I tried to convey that very clearly. But you tell Mr. Hill, I hope that he got knocked off. You make sure you tell him that. Because he knows better than to be in the midst of some argument before the court and to step out of the courtroom without being released from the courtroom. So there's probably an apology or something in order if he exited himself from this courtroom without having permission to leave the courtroom.
Yeah, I'm
And
sure that's
so-
not what happened.
Well, I'm really hoping, and I know that he'll be honest with me, and I know he'll be honest with you, and I don't want anything that's dishonest. If he left this courtroom without permission to leave voluntarily on his own, then he needs to correct that. He will need to correct that. And he has a good relationship with this court, as the firm has a good relationship with this court, because this is not the kind of behavior that I've ever seen displayed. But please make that very clear. And my ruling was based upon what I see in front of me at the moment. I already said that if there is something that either party wants to bring before me, you want to file a motion, Ms. Lipscomb wants to respond to any motion that you file, she'll have the opportunity to do that, and I will conduct a hearing on that issue and try to determine what the outcome should be, right? That's enough for today, ma'am. If they believe that you somehow violated some rule that requires that the court assess fees, they're going to put it in writing and send you a copy of that motion, and then you'll have a chance to respond to that motion in writing, and then the court will conduct a hearing on it and make a decision as to the outcome, right?
Your Honor, I would like to state that I was told that on January the 29th, I actually came to the court to file.
So somebody is alleging that something happened different than what you're saying. If that's what they want to allege, then they can file their motion. If they file a motion, then I'm sure you will file a response to their motion. And
Yes.
I will hear your response, I'll hear their motion, and I'll make a decision as to the outcome. That's why you can't argue that today. Don't go off of mute again. Don't go off of mute. I'm done with this case, right? And Mr. Potts, I think that you are very clear. I'm not trying to be hard on you. No, I don't want to hear anymore. I'm not trying to be hard on you, but you need to tell Mr. Hill what I told him, because we don't conduct business that way. That's not the way that you do it. Nobody can do that before the court, period.
And Your Honor, I would have to take off of work. Like, I would have to take off of work, Your Honor.
I tell you what, I think that you're having a hard time with following my directions. When I told you that if somebody files a motion against you, you file a motion, you file an answer, and then the court will set a court date on that. I think you heard that, and every time I put you on mute, you continue to come back in to talk. So I don't want to hear anything else. All right, so let's clear that part up. And if you wish to file a motion on the other issue, when you file that motion, serve the other party, and then the court will set up a hearing so the parties can have a hearing on that issue. All right, good day, gentlemen.
Thank you, Judge.